The Committee on Homeland Security, Justice, and Public Safety hearing of June 5th, 2025 is hereby called to order. Good morning, colleagues, staff, testifiers, listening and viewing audience. June is Men's Health Month. Men typically do not like going to the doctor. Please schedule a physical. The best medicine is preventative care. Tomorrow, June 6th through June 11th, National Gun Violence Awareness mark the beginning of Wear Orange Week. So please wear orange all week long. We have an extensive agenda, so let's begin. Madam Clerk, can I have a roll call, please?
Senator Angel Bolquez Jr. Senator Bolquez present. Senator Angel Bolquez present. Senator Dwayne M. DeGraff. Senator DeGraff absent. Senator Ray.
Is there any correspondence to be read into the record?
No, they aren't.
Madam Clerk, please read today's agenda into the record.
Committee on Homeland Security, Justice, and Public Safety. The 36th Legislature Committee on Homeland Security, Justice, Public Safety will meet on Thursday, June 5th, 2025 at 10 a.m. in the Earle B. Ottley Legislative Chambers on St. Thomas, U.S. Virgin Islands. Official agenda. Block 1, 10 a.m. to 11 a.m. Bill number 36-0020, an act amending Title II Virgin Islands Code, Chapter 1, Section 6, allowing the police chief of the legislature, the sergeant of arms, or any security officer of the legislature who has peace officer status to arrest a person who neglects or refuses to appear before the legislature in obedience to subpoena. Sponsored by Senator Marvin A. Blyden. Invited testifiers, Honorable Mario Brooks, Commissioner, Virgin Islands Police Department. Mr. Terrence D. Manning, Capital Police Chief, Legislature of the Virgin Islands. Block 2, 11:15 a.m. to 12:30 p.m. Bill number 36-0020, 0027, an act amending Title 5 Virgin Islands Code, subtitle 3, Part 1, Chapter 311 by enacting Jah'niqua's law, requiring a defendant to pay restitution in the form of child maintenance if the victim of the offense was the parent or guardian of a minor child or dependent, and if the defendant was convicted of neglect homicide by means of motor vehicle, a violation of Title 20 Virgin Islands Code, Section 504, while under the influence of or affected by intoxicating liquor or narcotic drugs, or was convicted of driving under the influence of intoxicating liquor or controlled substances, a violation of Title 20 Virgin Islands Code, Section 493, which results in an accident that causes the victim to become disabled or totally and permanently disabled. Sponsored by Senator Kenneth L. Gittins. Invited testifiers, Honorable Mario Brooks, Commissioner, Virgin Islands Police Department, Honorable Gordon Ray, VI Attorney General, Virgin Islands Department of Justice, Mr. Frank Harris, Director of Governmental Affairs, Mothers Against Drunk Driving. Lunch break 12:30 p.m. to 1 p.m. Block 3, 1 p.m. to 3 p.m. Bill number 36-0057, an act amending Title 5 Virgin Islands Code, Chapter 314, Section 3733, subsection A, to require automatic expungement of the arrest record and complaint or information when the accused has been acquitted. Sponsored by Senator Alma Francis Heiliger. Invited testifiers, Honorable Mario M. Brooks, Commissioner, Virgin Islands Police Department, Honorable Gordon Ray, Esquire, VI Attorney General, Virgin Islands Department of Justice. Ms. Julie Smith Todman, Esquire, Chief Public Defender, Virgin Islands Office of the Public Defender. Bill number 36-0024, an act amending Title 14 Virgin Islands Code, Chapter 85 by adding Section 1710, declaring a person incapable of consent to sexual relations while the person is in police custody. Sponsored by Senator Ray Fonseca. Invited testifiers, Honorable Mario M. Brooks, Commissioner, Virgin Islands Police Department, Honorable Gordon Ray Esquire, Virgin Islands Attorney General, Virgin Islands Department of Justice. Ms. Julie Smith Todman, Esquire, Chief Public Defender, Virgin Islands Office of the Public Defender. Ms. Anya Stewart, Executive Director, Family Research Center, Inc. Block 4, 3:15 p.m. to 4:15 p.m. Bill number 36-0031, an act amending Title 23, Virgin Islands Code, Chapter 10, Subchapter 4, Section 1073, to exempt the public safety agency or private safety entities from liability for acts of negligence in the operation, administration, or maintenance of a 911 service unless the acts are committed in a grossly negligent manner or are committed with willful intent. Sponsored by Senator Alma Francis Heiliger. Invited testifiers, Honorable Gordon Ray Esquire, VI Attorney General, Virgin Islands Department of Justice, Honorable Daryl Jackson, Director, VITEMA. That concludes the reading of the agenda, Mr. Chair.
Thank you, Madam Clerk. At this time, I'd like to recognize the presence of our non-committee members, Senator Marvin Blyden, and non-committee member, Senator Nobel Francis, Jr. The testifiers for this block are ready. Who speaks to this bill? Senator Blyden, you're recognized.
Thank you so much, Mr. Chair. Good morning to my colleagues, testifiers, staff, central staff, and members of the viewing and listening audiences. Today I'm here to present a bill which has profound implications and profound importance in representing and preserving the principles of government and a separation of powers between three equal branches of government. The gathering of information through legislative hearings and inquiries is one of the most important parts of the legislative process. It is impossible to pass good laws and to carry out oversight responsibilities without timely and accurate information. Therefore, the issuance and enforcement of subpoenas has always been recognized as part of the inherent power of legislative bodies. Consider the following passage from a 2019 Congressional Research Service report on the enforcement of subpoenas. An individual, whether a member of the public or an executive branch official, has a legal obligation to comply with a duly issued and valid congressional subpoena, unless a valid and overriding privilege or other legal justification permits non-compliance. The subpoena, however, is only as effective as the means by which it is potentially enforced. Without a process by which Congress can coerce compliance or deter non-compliance, the subpoena would be reduced to a formalized request rather than a constitutionally based demand for information. We have seen this scenario play out all too often on the national stage. During President Trump's first term, over 24 officials refused to appear in response to congressional subpoenas. Some of you may remember that during a Washington lobby visit in 2019, we met with Representative Payne from New Jersey, yes, who bluntly told us that his committee could issue all the subpoena he wanted, but that administration, which is the Trump administration officials, simply would not apply or come to the Congress chambers. Because recent Congress has chosen not to use its power to compel attendance, it has become a toothless tiger. In order for a legislative body to be otherwise, it must recognize and utilize its power, if necessary, to compel attendance and to provide information to the body. At the end of the day, this bill is about a simple question. Does the legislature consider itself a separate and equal branch of government or not? That's the first question. And are we serious about our mandate to represent our people and to gather the information we need to do that job effectively or not? Those are the two questions I have for my colleagues. This is why, this is where this bill comes in. Bill number 36-0020 affirms and clarifies the arrest powers of the legislature's Capitol Police in reference to persons who ignore or neglect an order to appear pursuant to a legislative subpoena. This bill updates Title II to deal with the process of enforcing subpoenas. That's what it basically does. It deals with the process of enforcing subpoenas. The existing language of the code currently calls for the legislature to issue an order to a member of the territorial police force to carry out an arrest. However, this language was written decades before the legislature had its own sworn peace officers. Further, because there are a number of instances in the code that refer to police officers of the VIPD separately from other peace officers, it is not entirely clear that our Capitol Police are included in the definition of territorial police force. In Title II, Section 6, this must be made crystal clear, and this bill does that. It is high time, I believe, that we update the law to reflect the fact that we have our own peace officers, and it is even more important that we preserve the power of the legislature to gather information and carry out its role as a separate and equal branch of government. I have further information that I will present during the questions and answer period. But for now, I humbly ask for support from my colleague in this most important measure. Thank you so much, Mr. Chair, for the time to introduce my bill.
Thank you, Senator Blythe. Good morning, testifiers. Kindly state your name and your title for the records. We'll begin with the Assistant Commissioner, Sean Santos.
Good morning, Honorable Clifford Joseph, and all present here today. My name is Sean Santos. I am the Assistant Commissioner for the Virgin Islands Police Department.
The next testifier. Mr. Cornelius.
Morning, Senator.
Identify yourself. State your name and title. State your name and title.
Definitely, sir. Good morning, Houston Cornelius, the Chief of Police, St. Croix District.
Good. Okay, Assistant Commissioner, could you... Oh, sorry, Mr. Manning.
Yes, good morning, Chairman of the committee. Terrence Manning, Capitol Police, U.S. Virgin Islands Legislature.
Thank you. Assistant Commissioner, could you go ahead with your testimony?
Yes. Mr. Chairman, distinguished members of the Senate, thank you for the opportunity to testify today in this matter. Again, I am Sean Santos, Assistant Commissioner of Virgin Islands Police Department. On behalf of Police Commissioner Mary Brooks, I submit this testimony in opposition of Bill number 36-0020, which seeks to amend Title II of the Virgin Islands Code, Chapter 1, Section 6, by allowing the police chief of the legislature, the sergeant of arms, or any security officer of legislature who has peace officer status to arrest a person who neglects or refuses to appear before legislature in obedience to a subpoena. While I recognize and support the legislature's authority to compel testimony and maintain order within its chambers, this bill raises serious legal, operational, and public safety concerns. We respectfully urge that this legislation not be approved based on the following rationale. Across the United States, it is exceedingly rare for legislative police personnel to possess unilateral arrest powers in subpoena enforcement. Most state legislatures and even the U.S. Congress rely on judicial or executive branch agencies, such as the courts or local state law enforcement, to enforce the subpoenas and manage contempt proceedings. For example, in California, Texas, New York, and Florida, enforcement of legislative subpoenas require court involvement and due process protections. This maintains separation of powers and ensures individuals have the right to contest a subpoena before facing detention. The Congressional Research Service notes that while Congress has the inherent authority to enforce subpoenas, however, criminal contempt proceedings are referred to the Department of Justice, and civil enforcement occurs through the courts, not through the Capitol Police action. The potential for abuse and politicalization. Granting legislative officers arrest power over subpoena non-compliance opens the door for political retaliation, selective enforcement, or suppression of dissent. Even the appearance of political motivation in enforcing legislative subpoenas undermines public trust in democratic institutions. Enforcement of subpoenas should remain neutral and detached from the legislative politics. Allowing legislative appointees to execute arrests risk politicizing what should be a strictly judicial or administrative function. The Virgin Islands Legislature already possess legal tools to address the subpoena non-compliance. The matter may be referred to the Attorney General for criminal contempt proceedings. A court may issue a bench warrant for the individual of individuals' arrest following due process hearings. These mechanisms preserve the constitutional separation of powers while ensuring enforceability. Authorizing legislative officers to perform arrests could have a chilling effect on civic engagement, especially in our local community, who is in most cases are already wary of government overreach. The perception of legislative intimidation could discourage residents, both white and blue collar, from participating in hearings, providing testimony, or attending meetings, ultimately weakening transparency and democratic governance. In closing, while we acknowledge the legislature's vital oversight role, the proposed bill introduces unnecessary risks, lack of national precedent, and raises serious legal and civil rights concerns. It would be more prudent to reinforce existing subpoena enforcement procedures through judicial and law enforcement partnership, ensuring public accountability, due process, and institutional integrity. I urge this body to consider these risks and vote against this bill passage, bill number 36-0020. Thank you for your time and consideration, and we will remain on standby and welcome any questions from the committee.
Thank you. Mr. Manning, Chief Manning, can you go ahead with your testimony?
Yes, Senator. Good morning. Senator Clifford A. Joseph Sr., Chair of the Committee on Homeland Security, Justice, and Public Safety, other members of the committee, and non-committee members present. My name is Terrence Manning, Capitol Police Chief, Legislature of the Virgin Islands. I was asked to be here to provide testimony as it pertains to Bill number 36-0020, an act amending Title II, Virgin Islands Code, Chapter 1, Section 6, allowing the police chief of the legislature, the sergeant at arms, or any security officer of the legislature who has peace officer status to arrest a person who neglects or refuses to appear before the legislature in obedience to subpoena. Capitol Police is a division of the Legislature of the Virgin Islands that includes over 20 post-certified law enforcement officers. A post-certified officer is a peace officer who has successfully completed the police officer standards and trainings post-board certification process. This process includes completing a post-approved basic academy, passing the post-certification examination, and undergoing a background check. The basic academy is the training standard for police officers, deputy sheriffs, and other classifications of peace officers to include updates to training at least yearly. Capitol Police officers are post-certified officers by post in the U.S. Virgin Islands. Our post-certified officers can make arrests. Arrest being the seizing of someone by legal authority and taking that person into custody. This completes my statement, and I stand ready to answer questions you or the committee may have.
Thank you for your testimony. At this time, I'm requesting for legal counsel to be on the legislature floor. And the Committee on Homeland Security and Justice will stand on a 2-minute recess. The committee is back on record. Point of information through the chair to Senator Blyden, legal counsel. You recognize Senator Blyden.
Thank you so much, Mr. Chair. Through the chair to legal counsel, good morning, counsel. My point of information through the chair is as a result of Assistant Commissioner Santos' testimony in respect to the bill raises serious legal, operational, and public safety concerns. But I want to deal with the legal part. The other part I'll deal with during my line of questioning. In terms of bill number 36-0024, do you see anything that's going to raise legal, serious legal, public safety concerns in respect to the intent of the bill in terms of having our Capitol police officers have the authority to assure that they can have subpoena powers, to assure that individuals show up and we get a chance to do our due diligence in terms of our responsibility as senators?
Legal counsel, you recognize.
Yes, through the chair to Senator Blyden. So I will have to rephrase to make sure that I'm answering your question correctly in a nutshell.
Okay, before you answer the question in a nutshell, let me try and simplify it for you. Right now, as it stands, to issue subpoenas, our officers will have to go to VIP and give it to them for them to carry it out. But right now, we have official officers that went through the same post and everything like VIP officers, so there is no difference in their training, in their certification, in anything. There is no difference. So right now, all I'm trying to do is assure that our officers have the same authority to carry out subpoenas. Reason being, based on what I saw in Congress and based on what's happening in the space right now, our officers have the right to assure that they can carry out their duty, to assure that if, for instance, if there's individuals that need to come and testify from the executive branch, any governor cannot tell their commissioner, don't send them down, and we don't have the power to arrest them. All I'm trying to do is make sure that our officers have the right to do their job, and we have a right to make sure that we do our job on behalf of the people. So I just wanted to simplify for you so you can understand where I'm coming from in terms of the bill intent.
Okay, through the chair to Senator Blyden. The question is whether, well, there seems to be several questions. So the first question is whether or not the Capitol Police has the authority to issue subpoenas, and that answer is yes. The second question is whether or not the Capitol Police has the authority to, in fact, effectuate an arrest in conjunction with carrying out a subpoena. And essentially, this is what this bill is seeking to do, because presently in Title II, Chapter 1, Section 6, it is not clear that the Capitol Police would be the entity to actually make the arrest. It says that it's the territorial police force. So this is what this bill is seeking to do. The Capitol, the legislature doesn't have the inherent authority to make sure that it carries out the force and effect of its subpoenas. As to the other policy questions, those are not legal questions for the legal counsel to answer.
Thank you so much, Counsel. Thank you so much, Mr. Chair.
Yeah.
Point of information.
Point of information. Senator Giddens, you recognize.
Thank you, Mr. Chair. I want to clarify a couple of things. First off, these officers don't issue subpoenas, rather they serve subpoenas, one. And I wanted to clarify something that the previous senator just stated about the officers will have to go to the VAPD to have them serve the subpoenas. That is not so. Again, they have that full authority to do so under the Peace Officer Standard Training Council's certification. And as when we get to the part where we're deliberating the bill, I'll tell you about the redundancy and the confusion and conflict that I'm seeing that's being caused just in those questions posed to legal counsel just now. But I wanted to clarify the record on those two things. Thank you.
Thank you, Senator. Legal counsel, who is the territorial police force?
Mr. Chair, the Territorial Police Force is the Virgin Islands Police Department.
Thank you. One more question, legal counsel. The Virgin Islands Police Force, but at times the carnivals and different time of the year, the peace officers from different department works along with the police force. So are they, so it's just the Virgin Islands Police Force will be recognized as the territorial police force?
Yes, Senator.
Thank you. Senator Blyden, you're recognized.
Thank you, Mr. Chair. Point of information to the Chair to Legal Counsel. In Title 5, Section 3561, it clearly distinguishes between different types of peace officers, listing various positions, including the security personnel of the legislative when on duty, and then at least when it comes to the last category, in a number of different police forces, right? And just 6 months ago, this body passed Act number 8979, which contained provisions regarding the retirement of certain government employees and the re-employment of government employees. And in that act, the legislature itself makes a distinction between police officer and peace officer and Capitol Police. As the measure lists each entity separately. So there is confusion, but this bill seeks to do otherwise. Thank you so much, Mr. Chair.
Thank you. I want to recognize the presence of committee member Senator Dwayne DeGraff. Morning, sir. Okay, colleagues, we will begin with a 3-minute round. I'll give you the order of the first senator will be Senator Angel Balquez Jr. Second senator will be Senator Avery Lewis, Senator Franklin D. Johnson, Senator Marvin Blyden, Senator Ray Fonseca. Senator Kenneth L. Gittins, Senator Nobel E. Francis Jr., Senator Dwayne D. DeGraff, and now then Senator Marvin Blyden. Good. For this round. So, Senator Balquez, you are recognized for your 3 minutes.
Thank you, Mr. Chair. Good morning, Mr. Chair. Good morning, colleagues. Good morning to the testifying panel of the Virgin Islands Police Department and the Director of the Capitol Police, Mr. Manning. Chief Manning, you mentioned that the Capitol Police officers are post-certified, and I'm assuming that post-certification comes with specifically, it prepares officers to carry out arrests. Currently, are officers in the legislature able to arrest, yes or no? I didn't hear the response.
Yes, Senator.
So what is prohibiting officers from arresting due to a subpoena being issued or served?
Senator, that's more of a legal question than it is for us to answer at Capitol Police.
Okay. Well, let me shift over to Chief Santos then. Good morning, Chief.
Good morning.
Or Assistant Commissioner Lord, sorry. I apologize.
That's okay. I've been in position long enough.
Don't arrest me. But Assistant Commissioner, I wanted to know, you expressed concerns about, in your testimony, about politicization.
Yes.
I hope I pronounced that properly, but could you elaborate on what safeguards are missing from the bill now that would otherwise ensure neutrality?
Yes, Senator, good question. One of the biggest issues that we viewed about when we reviewed the bill is that it does need some updating. And not only that, that as we look into the process, we're just speaking, our biggest factor here is to ensure that the process is being followed, in which the formulation of the subpoena comes from this body. Once it comes from this body, yes, it is given to the law enforcement officer to follow through. But however, there's two differentiations when the body is in session and when it is not in session. So over in, if I could direct your attention to Title 2, Chapter 1, subsection 8, that speaks about report of contempt, because the subpoena has been issued. So after the subpoena has been issued, now there's a report of contempt to judicial compulsion in B, where it says if the contempt is committed before a committee when the legislature is not in session, the District Court of the Virgin Islands may compel the attendance of the witness and given the testimony and the production of books, papers, documents, and accounts as required by the subpoena issued by the committee on the filing by the committee of a petition to the court asking that the witness be compelled. Because as it stands right now, not coming to the body for a subpoena is not a crime. So that's why, we have an issue with it.
So is that, if I, Mr. Chair, I heard my time, but if I may wrap up, please.
Go ahead and wrap up.
Thank you, Mr. Chair. So is that the specific legal citation you mentioned in your testimony that you believe the bill might infringe upon if passed? Is that the section that you were referring to?
Yes.
Okay. So I believe that as we continue the discussion, and of course we have legal counsel here, we could perhaps get some feedback from legal counsel on that specific citation. Thank you for the time, Mr. Chair.
Senator Bladney, you recognize.
For your point of information.
For your point of information.
Thank you so much, Mr. Chair. Based on Assistant Commissioner Santos' statement right now when it comes to the code in respect to subpoenas, etc., and session, we cannot have anyone subpoena to come to speak if they're not in session, so that's irrelevant. The subpoena is for them to appear to speak at the session or at the hearing. So that's irrelevant because he is correct. We cannot do that. But we are talking about subpoenas to come to testify. And if there is no hearing or session, you cannot testify. You cannot. So I just want to clarify that for the record. Thank you so much, Mr. Chair.
Thank you. At this time, we recognize Senator Avery Lewis for his 3 minutes.
Good. Point of information.
Good.
Hold point. You recognize Senator Giddens for your point of information.
Thank you, Mr. Chair. Mr. Chair, we might need more than 3 minutes discussing this because people need to really understand the dynamics of this. A subpoena is to ensure the appearance of an individual. To ensure the appearance. even when that person comes, he or she still has the right to plead the fifth. So the subpoena don't compel you to testify. It compels your appearance. Thank you.
Thank you, Senator. Senator Lewis, you're recognized for your 3 minutes.
Thank you, Mr. Chairman. Good morning, colleagues. Good morning, testifiers. Good morning to the people of the Virgin Islands. Good morning to the listening and viewing audience, wherever you may be. Hope you're having a wonderful day. Chief Manning, in your view, what operational challenges currently exist that this bill is intended to address?
It ensures that the person that is selected to testify shows and is able to give their testimony if they choose to.
Okay. You mentioned earlier in your testimony that Capitol Police officers are post-certified. Can you clarify for me today whether all current officers meet these standards, and how often are they required to undergo recertification or continuing training?
All police officers within Capitol police officers, peace officers are post-certified and retrain and are recertified by post yearly.
With the authority to arrest now being expanded to the legislative security personnel, what oversight mechanisms are in place to ensure proper use of this power?
We have rules and regulations that we work on. We have the governing information that post sends out for the processes that the officers are supposed to follow.
Chief Santos, Assistant Commissioner Santos.
Yes, Senator.
You raised concerns about the separation of powers. Could you elaborate on how this bill, in your view, blurs the lines between the legislative and executive branches within the Virgin Islands constitutional framework?
Thank you, Senator. It's the separation where the executive branch and the judicial branch is being left out.
Okay. In your research, right, or your experience, has any U.S. jurisdiction granted its legislative police force unilateral arrest authority for subpoena non-compliance?
I'm sorry, Senator, can you rephrase that question?
Based on your knowledge, you did some research, right?
Yes.
Did you come about where any jurisdiction, another U.S. jurisdiction, granted its legislative police force unilateral arrest authority for subpoena non-compliance?
Based on the research, Senator, we found that I haven't found any other jurisdiction that grants it. Now, the Congressional Capitol Police, they do have, but they still too have to go through a process. Even though the subpoena has been formulated by the legislative body, there's still a process in which they may go through with the judicial branch.
All right, Mr. Chair, if I could ask one more follow-up question, please.
Yes, you may.
Chief Manning, how does Capitol Police coordinate with the Virgin Islands Police Department when it comes to matters like arrest or detention? Do you foresee any jurisdictional conflicts arising from this bill?
In the case of arrest, which usually also includes the processing and thereabout, yeah, we would definitely need to coordinate with Virgin Islands Police Department for those assets to be able to process the person.
So based on this bill, do you foresee any jurisdictional conflicts arising?
Not if the legalities are worked out during the processing of the bill, no.
Okay. Thank you, Mr. Chairman. I hope we get another round to ask some more questions. Thank you.
Yes. You recognize Senator Blyden for point of information.
Thank you so much, Mr. Chair, to the Chair, to the legal counsel. Legal counsel, I know that my colleague spoke to individuals showing up but pleading the fifth where they don't have to speak. But can a subpoena be compelled to produce documents? I think that's important.
Through the chair to Senator Blyden, well, yes, you have different types of subpoenas. So you have a general subpoena which compels the person's appearance. You may have a subpoena ducis tecum, which means that the person has to appear and bring documents or to produce certain documents.
Thank you so much for putting that on the record. Thank you so much, Mr. Chair.
The chair to legal counsel, do you wanted to weigh in on something else?
Yes, Mr. Chair, there was a question that was asked previously in terms of whether or not the Capitol Police has the authority to make arrests, and yes, they do, especially, well, not especially if there's some crime or something that is infraction that is being committed. However, here in Title 2, Section 6, the legislature specifically states here, or the legislation, whoever neglects or refuses to appear before the legislature or any of its committees in obedience to a subpoena may be arrested by a member of the territorial police force on the order of the legislature or committee. And so therefore, this specific section compels the use of the Virgin Islands Police Department in order to enforce a subpoena. And so this is why this legislation is seeking to amend that section so that where the Capitol Police now would be the persons enforcing the subpoena. But other than for this section, the Capitol Police does have the authority to make arrests if crimes are being committed.
Question, legal counsel. The statute, the way it is right now, prior to the Capitol Police being peace officer status, does that change the capacity of the legislative police force?
I am not sure that I understand that question. Change their capacity in what way? To be able to arrest someone who disobeys a subpoena?
I was asking prior to them becoming peace officer, when you used to train before, they became peace officer, they had arresting powers prior to now being peace officers?
Previously, the Capitol Police Force were considered security of the legislature. They did have peace officer status at that time, so yes, they could make arrests as well.
Again, as security officers, that's the question I really wanted to ask. I wanted to ask it when they were just security officers. One minute, Senator. Did they have arresting powers? That was the question.
Yes, they did.
Okay.
If they were considered peace officers, yes.
Thank you, legal counsel. Senator Gittins, you're recognized for your point of information.
Thank you. To your question, sir, if they were not post-certified, then they didn't have peace officer status, and the security officers themselves were not peace officer certified. In the 30th legislature, when I came in as a freshman senator, is when we transitioned to now having peace officer status. And we're still in the transition phase now where we're moving away from legislative security to that of the Capitol Police Division of the legislature. That piece of legislation right now is supposed to be in committee and not here yet, but prior to, the security officers themselves did not have any peace officer status. If the sergeant at arms or assistant sergeant at arms were law enforcement officers prior and still had that certification, then they had the arrest powers according to the Virgin Islands Code, but not the regular uniformed security officers.
Thank you, Senator. At this time, we recognize Senator Franklin Johnson for your 3 minutes.
You could go on to the next senator. He left the room for a minute.
Well, at this time, we recognize Senator Gittins for your 3 minutes.
Thank you, Mr. Chair. Mr. Chair and colleagues, you know, there's some redundancy here in this piece of legislation, and as a former law enforcement executive myself, I must oppose this piece of legislation on the grounds that it is legally redundant under Title V of the Virgin Islands Code, that all sworn peace officers in the Virgin Islands have already have the authority to effect arrests for failure to comply with lawful subpoenas. There's no need to duplicate or selectively restate this authority in separate statutes. You know, we run a risk of confusion and conflict when we do this. The bill could cause more harm than good by introducing ambiguity into our enforcement framework. You know, the peace officer status is already clearly established in the post standards, which is a whole thick document here. And creating carve-outs for certain positions within the legislature could only lead to unnecessary jurisdictional conflicts, as I've been saying, and confusion about the rules. And the integrity of the uniform standards, you know, as someone who spent decades upholding the law, I believe strongly in consistent and uniform standards for law enforcement across the board. This bill undermines that by creating the perception that legislative security officers require additional or separate powers when in fact they already possess them under the existing laws of the land. You know, there's a political optic here where we must also be mindful on how this bill appears to the public. Evaluating certain legislative staff roles to explicitly have arrest powers, even if they already do, could be seen as an overreach by the legislature. And that is not what we want to do. This is about public trust and as much as it is about legal authority. And lastly, we got to focus on enforcement and not expansion. Our priority should be on ensuring that existing enforcement powers are used effectively and not on expanding or reiterating them in legislation where it's not necessarily needed. Let's support our peace officers by offering the laws already on the books and not cluttering the legal code. And for this, I firmly stand that I cannot support this measure. I've already had this discussion and stated that in various areas of the Virgin Islands Code, it's already clear of the authority of anyone possessing that peace officer standard training council certification, post-certification. Thank you, Mr. Chair.
Thank you, Senator. At this time, Senator Noble E. Francis Jr., you're recognized for your 3 minutes.
Thank you very much, Mr. Chair, and good morning to you. Good morning to my colleagues. And of course, good morning to the fine individuals from the Virgin Islands Police Department. We have Assistant Commissioner Sean Santos and Chief Cornelius, as well as Chief of the Capitol Police, Mr. Terrence Manning. I'm having some procedural challenges with this conversation this morning. And I wanted to go back to legal counsel briefly in an explanation. I want to say that I appreciate the testimony by both testifiers this morning. Of course, the police department have their position in respect to this, and I respect their position as well. My procedural challenge really hinges around that we're seeking to place our Capitol Police in a real untenable situation when we talk about them initiating an arrest for the issuance of a subpoena, because subpoenas can be issued by the Capitol Police. It's served on the behalf of a committee that have determined that a subpoena should be issued, and then it's served by the Capitol Police. Once that subpoena is issued, then it's the responsibility of the recipient to make an appearance. When that does not happen, then obviously the committee needs to come back together, in my understanding, to make a determination how to proceed forward, and the non-appearance of that subpoenaed individual now before the legislature. And from my reading, that because there is an arrest trigger that's required, obviously there needs to be some probable cause and whatever to initiate that arrest. And obviously on the serving of the subpoena, there's no violation. You serve the subpoena, you await them to make the appearance. When they don't make the appearance, then the committee needs to come back together to make a determination, the course of action to be taken there. And from my reading, then that requires a referral to the court to then make that determination. Once the determination is made by the courts, then any peace officer with peace officer status and authority then can initiate an arrest on the behalf of the contempt that have then occurred, and then then the person is then brought in based on that court determination. Madam Legal Counsel, Attorney Siku, in terms of the procedural challenges I'm having, is not the way it'll work. Obviously, there needs to be some trigger subsequent to the failure of that subpoenaed individual made by some committee or the entire body?
Through the chair to Senator Francis. So the process that you just described is correct. However, there's one part that is missing due to Title II, Chapter 1, Section 6, which here states that someone who does not obey a subpoena may be arrested by a member of the territorial police force. So presently, the Capitol Police does not have the authority to arrest someone who disobeys a legislative subpoena. Because this section is very specific. I've heard mention to Title V, where there's a general statute giving all peace officers arrest powers in terms of subpoenas and, other documents. However, that is general. Specifically here in this section, it refers to the territorial police force. The Capitol Police is not considered a part of the territorial police force. So while you accurately describe what will happen once a subpoena is issued, whether it's by a committee or by the legislature, it is then served by the Capitol Police and the various proceedings. However, what happens when the committee or the legislature may want to effectuate an arrest of a person who disobeys the subpoena? And that's where the issue is.
So again, based on your reading and your explanation there, still the Capitol Police will not be able to initiate the arrest outside of the court's intervention. Is that correct?
No, they will not be able to effectuate an arrest outside of the territorial police, which is the Virgin Islands Police.
Is a marshal considered territorial police?
No, a marshal is not considered a territorial police.
Okay, so then I would imagine that we have some work to do, then not just to include Capitol Police into this, but rather we need to look at, and I think under Title 3, under Title 23, and I'll take a review of that again, but I think under Title 23 enjoins all of the peace officers to be law enforcement officers. However, then we have deeper work to do in respect to ensuring that all of the peace officers, to include the Superior Court as well as the Supreme Court marshals, are enjoined into the territorial police so that they could initiate such arrest powers based on the court mandates.
Yeah, but through the chair to Senator Francis, this section and this title in particular deals with the legislative power. So that will not, having the marshals and every other law enforcement personnel or peace officer will not fit under this section.
Roger, I understand that. That will come under Title 23, correct?
Yes.
Okay, very well. Thank you. I have no further questions in regards to this matter. Obviously, we still have some work to do on this. Thank you.
Point of information.
Senator Gittins, you recognize for your point of information.
Thank you, Mr. Chair. And listening to the previous speaker, hence why I stated that carving outs for certain positions could lead to unnecessary conflicts, jurisdictional conflicts, and confusion. Now, where the council just spoke to Title II, it's obvious that that portion of the code needs to be amended as well. This is why we have to go through the code and make the changes as necessary. Now, back in the day, there was nothing known as Peace Officer Standard Training Council. It is since that piece of legislation came in now and then itemized who are peace officers within the territory. We no longer refer to it either as the Territorial Police Force. Police force is no longer. It used to be named Department of Public Safety. That was changed from back in 1984-85. It's now the Virgin Islands Police Department. But we still refer to terminology as Territorial Police Force, which is obviously creating a problem. So what we need to do is amend the code by simply calling them or referring to them as peace officers. And once we do that, that will include police force, Capitol Police, DPNR, DLCA, wherever other police we come up with, because even the hospital and UVI have law enforcement officers. And it seems like everybody wants this peace officer status now. And that's why you see that I don't support opening up this thing to every Jando that decides we want our own police force. Even GRS came here the other day for their own police force. Why? We're creating confusion, conflict and confusion. Thank you, Mr. Chair.
Thank you, Senator. Senator Johnson, you're recognized for your 3 minutes.
Good morning. Necessarily don't need 3 minutes, but through the chair to legal counsel, if I may. May I go proceed, the chair?
You could proceed.
I want to ask legal counsel, when someone does not show up to court for a subpoena, doesn't the marshals have that right to arrest once the judge gives that order?
Through the chair to Senator Johnson, yes, that's correct.
But I'm kind of confused here now, because for a minute I thought you were saying that only the territorial police can do arrests. But if I'm right, once the judge gives that order for someone that contempts or didn't show up, the marshals in the court has that right to do that arrest.
No, through the chair to Senator Johnson, I was answering a specific question by the previous senator, and the senator asked, unless I misunderstood the question, the senator asked whether or not a marshal can make an arrest if someone fails to obey the legislative subpoena. That was a specific question. The marshals can, in fact, make an arrest if with a court-issued subpoena.
So
Once
then,
the court directs the marshal to make that arrest for not following for not obeying the subpoena.
So, okay,
But this
perfect then.
body-
Why would we circumvent that now and allow our officers to go straight directly and do arrests? I think this thing needs to be looked over very carefully because I think we're creating some conflicts here. Because even in the very courthouse, the marshal has to wait till he gets that order from the judge to effectuate that arrest. He can't just do it. Now we're saying that we're going to start doing the court's work by telling them if effectuate the arrest. I think we need to look at this very carefully. And I appreciate what the assistant commissioner testimony was. We really don't want to go down that conflicting road where we're going to put our officers in a position to now be in some issues with political ramification. We have to be very careful of what we're asking for here. Thank you very much, Mr. Chair.
Thank you, Senator. Senator Fonseca, you are recognized for your 3 minutes.
Yes, thank you, Mr. Chair, and pleasant good morning to all the listening and viewing audience and colleagues and all the testifiers. Okay, so this piece of legislation is something that we encounter quite frequently in the legislature. As a matter of fact, just last week, no, today's Thursday, I think it was earlier this week, when we had the budget committee and several members of the administration didn't come down. So I can see where it would become political because I believe, I don't know for sure, but I believe they didn't come because the legislature and the governor was having a little flack. And the legislature was upset with a decision the governor had made, and, you know, we can't bring him down here. He sent his underlings, and the underlings sent us a letter for all kinds of different reasons why they couldn't show up. So I agree with the previous senator from Frederickstead, where I can see politics get involved with it. And so this bill, 36, would allow for the police chief of the legislature, the sergeant of arms, and any security officer of the legislature who has peace officer status to arrest a person who neglects or refuses to appear before the legislature in obedience. Now, I agree with it in principle. However, I think the greater harm is when someone comes down here and gives us false testimony. I think that's a bigger issue when someone comes and gives us false testimony, knowingly gives us false testimony or withholds testimony. And those things is what happens all the time. As a matter of fact, if you don't know part of the answer, the information sometimes is not volunteered. So I think it might be a little bit more prudent to reinforce the existing subpoena procedures through the judicial or law enforcement partnerships, because our main role here is to be the guardians of the funds, and we need to get testimony, you know, to ensure we get an accurate information. I know
Time.
in the last, Mr. Chair, can I just wrap up?
Yes, you may.
I know sitting in this committee when the vice president chaired this committee, I know we had, I think it was 2 occasions where the former police commissioner himself didn't appear before the committee, and you know, it's kind of uncomfortable, and I think that you know, we need to look at this because I can definitely see where politics could get involved with this matter. But I think I agree with the principle of it, and you know, I haven't made up my mind yet, and I'm still looking at all sides. Thank you, Mr. Chair, for the time.
Thank you.
information. Point of information.
Point of information.
Like-
No, wait, hold. Senator Blyden, you recognized for your point of information.
To the chair, to legal counsel. I have a question. Okay, thank you so much, Mr. Chair. Mr. Chair, my colleague just spoke in respect to procedures, etc. So, legal counsel say, for instance, the Capitol Police have the authority to actually serve the subpoena, right? How does that change in terms of impact when it comes to due process? What's the difference? What would be the difference if they had authority to do such? What would be the difference?
Through the chair to Senator Blyden, you asked what would be the difference in terms of due process if the legislative police has the authority to serve a subpoena?
Yes. What would be the difference?
They presently have that authority. There are really no due process implications in terms of serving a subpoena. The due process implication comes in when there is an arrest. And so, under the 4th and 14th Amendment, there are certain due process implications that would come in as a result of an arrest, because the person does have the right to be heard if they're being arrested. An arrest is considered a seizure of the body under the 4th Amendment. And so, under the 14th Amendment, there are certain procedural as well as substantive due process implications that will take effect.
In Chapter 6, to carry out the arrest, how would that impact due process?
The person would have to be given their due process. In other words, they would have to be read their rights, which is commonly termed Mirandized, that they have the right to seek counsel. They would have to be taken into custody and given that opportunity to confer with an attorney. And so there are several steps that they would have to be afforded in order to meet those due process requirements.
Exactly, and the same thing applies. So, thank you so much, Mr. Chair.
Thank you. Senator Gittins, you're recognized for your point of information.
Oh, I'm sorry. So,
Senator Francis,
okay, I
first.
think
I'll yield.
I'm sorry.
Senator Francis, you're recognized for your point of information.
Thank you very much, Mr. Chair. I just wanted, for the record, a point of information in respect to the scenario that happened earlier this week, where commissioners declined an invitation for our parents, had nothing to do with a subpoena concern. There was no subpoena issued in that matter. In my 11 years of being at the Senate, every single time that we have issued a subpoena, in fact, there was an appearance made by those individuals that was subpoenaed. So let's not conflate the issue. Once subpoenas are issued, those individuals appear.
Thank you. Senator Gittins, you're recognized for your point of information.
Thank you. And the former president just covered the first part of what I was going to state as well, because that was a matter of invitation and not a subpoena. And I'll just add that since the speaker before as well made mention as to when I chaired the committee and the commissioner in chief didn't show, the committee did in fact issued a subpoena. The subpoena was served by our personnel and they appeared at the legislature and provided the testimony that we asked for. So let the record reflect that the process in place does work. Thank you.
Thank you. Legal counsel, you want to clarify?
Through the chair to Senator Blyden. So I believe that part of what Senator Blyden was asking is if it would be the same due process that would be afforded, whether or not, it's the territorial police or whether it's the Capitol Police, and that answer is yes.
Senator Lewis, you're recognized for your point of information.
Thank you, Mr. Chairman. Mr. Chief Manning, currently, what's the procedure in when you or your team serves a subpoena?
When the subpoena is received from the legislature, we locate the person, make sure that the subpoena is properly delivered, sign off on the subpoena, and return it back to the legislature.
Has there ever been an instance where you served a subpoena and the individual don't appear?
Not that I know of.
Okay, thank you.
Thank you, Senator. I recognize Senator Dwayne DeGraff for your 3 minutes.
Thank you, Mr. Chair. Good morning, colleagues. Good morning, testifiers, all of you and listeners and present. I understand the intent by the senator, sponsor of the bill, but for me, I'm not going to turn a subpoena into an arrest warrant because, you know, having arrested people many years, one, you're going to get them a record. Two, I know the court has a system where when they send out a subpoena for you or they send the marshals for you, then you appear in contempt. Maybe we could look at giving a fine to somebody who refuses to serve, and maybe they have to pay half the fine and the whatever department. But I don't think to get the information from the people, for the people, we need to go down the route of arresting people, you know, put them under arrest. You have to appear, and I just don't like the word arrest. So if we could try some other process where we could create, like I said, maybe a fine system, maybe they come before and, you know, think tank, and we try come up with something. But to go to an arrest means you deprive them of certain things, of their rights, and to come to appear before the legislature, I don't want to go down that road, not me. But I do feel we need to have some kind of mechanism because we have, since I've been a senator, given subpoenas and the individual did not show up. I remember, I don't remember exactly who he was, but I remember being a part of a subpoena where they didn't show up. But again, to go out and arrest them and give them an arrest record and go through that, I don't think that should be the look of the legislature. I think we should be where we demand, we stay on a professional basis, and if it has to come to a system where they come before the body or they come before and a fine is assessed and or some kind of sanction or something based on our authority and powers, we restrict some of their budget, you know, whatever it is, but to go to an arrest, I think that's a bit far-reaching for me, in my opinion. I do understand the intent, but as of right now, I won't be able to support the bill with the simple word of arrest. If arrest was removed or you try some other format, is one thing, but that particular word is too powerful for me. Thank you for the time, Mr. Chair.
Thank you. Senator Blyden, you're recognized for your 3 minutes.
Thank you so much, Mr. Chair. And again, good morning to my colleagues. Good morning to the people of the Virgin Islands. And good morning, testifiers, and thank you so much for your testimonies. I want to thank legal counsel for being here to clarify many of the different requests today. We have 3 police officers in this committee today. We went through a lot. Our former president did a lot to assure that our police officers gain peace officer status, went through posts and everything. And that's a good thing. We gave them some amount of power and authority. But here it is, I'm hearing all type of excuses why we shouldn't do certain things. And that's unfortunate, in my opinion. That's very unfortunate. You spend a lot of time and money to assure that they got that status. But I'm hearing all kind of excuses as to why we can't do something or we shouldn't do certain things or we shouldn't support certain things. But it's okay, because as former police officers, you know, it would have been nice to hear from my colleagues and pull me up and tell me like this, that, the other, and I would have gotten it, you know? And we could have done something else or amend it to find other ways to assure that the bill passes. But it's okay. Nobody can bring none about housing. I know about it. I'm not going to pull them up, because that's the way I am. That's who I am. We are all colleagues. We all communicate. We all work with each other. But I don't like when you come on and flaunt. It's like, no, did the reason why, no, you have the bill the whole time. But it's okay. I want to say something, though, for real. This bill is not about arresting anyone. That is not my character. That's not who I am. That's not what I'm about. The bill is about enforcement, assuring that people show up when they're asked to, when they're subpoenaed, to make sure they come. If you don't want to be arrested, then show up. If you can't show up and we ask for documents, send the documents. You don't have to come. This isn't about arresting nobody. It's about assuring that we do our job. We do the work on behalf of the people. That's why they put us here. It ain't about arresting nobody. We have passed so many bills to assist people in second chances. We all do it, and that's what we're about. So we're not about arresting nobody. The bill just wants to ensure that what we invested in, our Capitol Police, have the same authority and privilege and mandate as VIPD officers. That's it.
Time.
That's it. But nonetheless, I thank all of my colleagues for their contribution. And again, I say, we must do better. We can do better, we should do better. That's all I have to say today, Mr. Chair. Thank you so much for the time, and I feel that just, thank you so much.
Thank you, Senator.
Point of information.
Senator Johnson, you're recognized for a point of information.
Thank you very much, Mr. Chair. I could consider myself a rookie still. I've only been here 5 years in comparison to my colleague here, 11, and my colleague over there, next 11. I had the committee on 2 different occasions subpoena the director of the Bureau of Correction, subpoena the Commissioner of Public Safety. When those subpoena went out, both showed up in this well. So I can say the process that we have, I'm 2 for 2. It works. And then when I lean to my colleagues and I ask them that been here prior to me, have they known anyone that got a subpoena that haven't shown up? And none of them could say it haven't. So for me, this process that we have here, it works. And if it, they say if it works, don't break it, don't fix it, leave it, let it continue. And when I saw the measure, I was trying to figure out where we're going with it. And as we continue, I just can't, what we have walking as far as I'm concerned. I did 2, and both of them showed up. And to stretch it a little bit more, when the police commissioner did show up, he was still looking to be hesitant. And I must say, the chair stand up and say, understand what condition you're there here under, Mr. Commissioner. Understand that you're here under a subpoena. And the commissioner complied and answered all my questions. So for me, this process do work. Folks that haven't showed up here wasn't subpoenaed. And people who haven't showed up when there was asked to come, that was not under a subpoena. So I must say that this process works as far as I'm concerned, and if it ain't break, don't fix it. Thank you very much, Mr. Chair.
Thank you. Colleagues, point of information, Mr. Senator Lewis, you recognize.
Yes. Thank you, Mr. Chairman, for recognizing me. Mr. Chairman, I see where we're trying to build on public trust. And I could see where this could murky the waters there, because we want people to be encouraged to come to the legislature to participate in the process. I could also see where this could cause quite legal fees as well, too. Because when we arrest somebody, we got to go to court, we got to do different things. Right here today, we're talking about expungement a little later this afternoon. You know, while I understand when people don't show up, the frustration it causes us here and so forth, because we really need information and we would like the testimony and the participation of not just the government officials, but even people in the private sector and, you know, regular civilians as well. And I also could see we're going to cost Capitol Police more training and so forth. Because then when you go to arrest somebody and they don't cooperate, that's a use of force and different things, you know, it's a whole hoopla of things that could carry on. So I just want us to be on the side of caution and the side of right. Thank you, Mr. Chairman.
Thank you, Senator. Colleagues, we have exhausted all the time for this block. I would forward Mr. Chief Manning 30 seconds. Yeah.
Thank you for the opportunity to be here, Mr. Chairman. Wanted to say definitely to the Capitol Police officers, thank you for your service and everything you do from today to every other day. To my colleagues at the Virgin Islands Police Department that help us with training and helping us to grow and continuing to grow that relationship with them, and to be able to follow the rules, laws, and regulations of the United States, Virgin Islands, the legislature, and we're here to provide whatever service is needed to do whatever is necessary to make sure that the people's business gets completed. Thank you for your time.
Thank you. The Committee on Homeland Security, Justice, and Public Safety stands in recess for 2 minutes. The Committee on Homeland Security and Justice Public Safety is back on the record.
Motion.
Senator Lewis, you're recognized for your motion.
Thank you, Mr. Chairman. Mr. Chairman, I move that Bill number 36020 enact amending Title 2 Virgin Islands Code, Chapter 1, Section 6, allowing the police chief of the legislature, the sergeant of arms, or any security officer of the legislature who has peace officer status to arrest a person who neglects or refuses to appear before the legislature in obedience to subpoena sponsored by Senator Marvin A. Blyden be held in committee and be called back by the order of the chair.
Second.
Objection.
I so move.
Second.
Objection? Motion. Motion was properly made and second. Made by Senator Lewis, seconded by Senator Fonseca. Objected to by Gittins. Objected to by Senator Gittins. Roll call.
Senator Angel Bolquez Jr.
Here.
Senator Dwayne M. DeGraff.
Yes.
Senator Ray Fonseca.
Yea.
Senator Ray Fonseca, yea. Senator Kenneth L. Gittins.
No.
Senator Gittins, no. Senator Franklin D. Johnson.
No.
Senator Johnson, no. Senator Avery L. Lewis.
Yes.
Senator Lewis, yes. Senator Clifford A. Joseph.
Yes.
Senator Joseph, yes. Mr. Chair, you have 5 yes and 2 noes.
Yes.
Okay.
Well, Bill number 36-002 will be held in committee at the call of the chair. Madam Clerk, call up the next bill in Block 2.
Block 2, Bill number 36-0027, an act amending Title 5 Virgin Islands Code, Subtitle 3, Part 1, Chapter 311, by enacting Jah'niqua's law requiring a defendant to pay restitution in the form of child maintenance if the victim of the offense was the parent or guardian of a minor child or dependent, and if the defendant was convicted of negligent homicide by means of motor vehicle, a violation of Title 20 Virgin Islands Code, Section 504, while under the influence of or affected by intoxicating liquor or narcotic drugs, or was convicted of driving under the influence of intoxicating liquors or controlled substances, a violation of Title 20 Virgin Islands Code, Section 493, which results in an accident that causes the victim to become disabled or totally and permanently disabled. Sponsored by Senator Kenneth L. Gittins. Invited testifiers, Honorable Mario Brooks, Commissioner, Virgin Islands Police Department, Honorable Gordon Ray, VI Attorney General, Virgin Islands Department of Justice, Mr. Frank Harris, Director of Governmental Affairs, Mothers Against Drunk Driving. Mr. Chair, that ends Block 2 of the agenda.
Who speaks to this bill?
Mr. Chair, I do. Gittins.
Senator Gittins, you recognize.
Thank you. Good morning to all. I'm pleased to formally introduce This vital piece of legislation in Bill number 36-0027, also known as Jah'niqua's Law, which seeks to amend Title 5 of the Virgin Islands Code, Subtitle 3, Part 1, Chapter 311. This bill addresses the profound and long-lasting consequences of negligent, reckless, or impaired driving on families in our community. This bill aims to provide long-term support for children who lose a parent or a guardian due to a reckless or impaired driving incident. A defendant convicted of negligent homicide or driving under the influence that results in death or permanent disability of a parent or guardian must pay child maintenance as restitution. Payments would continue until the child reaches the age of 18 years or 19 years if still in high school. The legislation introduces a restorative justice measure to hold offenders financially accountable for the long-term impact of their actions on the families they affect. We have all seen the tragic consequences that can result from driving under the influence, driving recklessly, or engaging in negligent driving behaviors. In cases where a victim of such an offense becomes disabled or permanently incapacitated, it is not only the victim who suffers. Families, particularly children, are left without support, stability, and financial resources. This bill simply seeks to provide a measure of financial support to the minor children of those victims, ensuring that their basic needs, such as child maintenance, are met in the wake of such devastating losses. Moreover, Jah'niqua's Law serves as an essential deterrence, sending a clear message that actions such as driving under the influence or recklessly will not only result in criminal penalties, but will also hold the defendant accountable for the long-term well-being of those affected by their actions. Colleagues, I urge you to support this piece of legislation as it provides a necessary safety net for families facing the aftermath of these preventable tragedies. By enacting Jah'niqua's Law, we are not only addressing the immediate consequences of impaired and reckless driving, but also taking a significant step towards reducing such behavior in our community. Thank you for your consideration of this proposed piece of legislation, and I look forward to working with all of you to ensure its passage and enactment. And remember, this is not just about those charged with drunk driving, but also reckless and or negligent driving. So you don't have to be under the influence of any intoxicant for you to be charged with this. Thank you, Mr. Chair and colleagues.
Thank you, Senator. Good morning, testifiers. Kindly state your name and title for the record. We'll begin with...
Good morning. Daphne O'Neill, Director of Office of Highway Safety, on behalf of Commissioner Mario Brooks of the Virgin Islands Police Department.
Thank you.
Good morning. Gordon Ray, Attorney General, Department of Justice.
St. Croix.
Good morning, Senator Sean Santos, Assistant Commissioner of the Virgin Islands Police Department.
And again, good morning, Senator.
Good morning.
Houston Cornelius, St. Croix District Chief of Police.
Who's going to read the testimony for the Commissioner Brooks?
That would be Director O'Neill on behalf of Police Commissioner Brooks.
You may proceed. Director Brooks.
Good morning to the chair, the Honorable Clifford Senior, legislative bodies and staff, members of the VIPD team, and to the listening and viewing audience. My name is Daphne O'Neill, Director of the Office of Highway Safety for the VIPD. I come before you on behalf of Police Commissioner Mario M. Brooks to discuss an act amending Title V, Virgin Islands Code, Subtitle 3, Part 1, Chapter 311, by enacting Jah'niqua's law. Mr. Chairman, distinguished members of the Senate, thank you for the opportunity to testify today on this matter. VIPD is honored to provide testimony in support of Bill 35-0318, commonly referred to as Jah'niqua's law. This vital legislation will hold defendants accountable for the financial impact of their reckless actions when driving under the influence, particularly in cases where their behavior causes death or disability to a parent or guardian of minor children. The necessity of this bill becomes clear when examining data from the Office of Highway Safety. In recent years, impaired driving has significantly contributed to fatal and serious crashes in our territory. For instance, in fiscal year 2023, the Virgin Islands reported over 5,000 traffic crashes, an increase of 8% from the previous year. Impaired driving accounted for several fatalities, with St. Croix being the hotspot for such incidents. For the period fiscal year 2020 to June 1st, fiscal year 2025, the DUI-related fatalities in the territory were St. Croix 7, St. Thomas 2, and St. John 0. However, for the same period, the number of persons injured in DUI-related crashes were 154 on St. Croix, 92 on St. Thomas, and 2 on St. John. The data further underscores the prevalence of DUI-related crashes that peak during the hours between 5 p.m. to 8 p.m. for the territory. On St. Croix, the highest crashes occur during the month of March, while on St. Thomas, it is the month of April. During those periods, enforcement efforts are heightened, but challenges persist in ensuring compliance with safety laws. The VIPD recorded a total of 390 DUI arrests for the period referenced in this testimony. The broader societal impact of these tragedies is devastating. When a parent or guardian is killed or permanently disabled by a DUI offender, the financial and emotional toll on their dependents is immeasurable. By addressing the gap, requiring convicted offenders to pay restitution in the form of child maintenance, recognizing the long repercussions for the family, Jah'niqua's law is essential. This proposed legislation aligns with our collective commitment to justice and public safety. It provides a mechanism to alleviate some of the burdens placed on families left behind, while sending a strong message about the consequences of driving under the influence. Moreover, it complements existing enforcement strategies, such as DUI checkpoints and patrols, which aim to deter impaired driving and protect lives on the road. We urge the committee to advance Bill 35-0318 and support its implementation as a critical step towards accountability and community safety. Together, we can ensure that justice serves not only to punish offenders, but also to support those most affected by their actions. The VIPD stands ready to respond to your questions. Thank you for your attention and consideration.
Thank you. Attorney General Ray.
Good morning. Well, it's 1 minute after noon, so good afternoon.
Good afternoon. You got both of them.
Chairman Clifford Joseph Sr., Committee on Homeland Security, Justice, and Public Safety members, senators, legislative staff, and the listening and viewing audiences. I am Attorney General Gordon Ray. It's an honor and privilege to appear before you this morning. The Department of Justice appreciates the opportunity to comment on Bill number 36-0027. We've completed a preliminary review of the bill and offer the following comments. Bill 36-0027 seeks to amend Title V of the Virgin Islands Code, Subtitle 3, Part 1, Chapter 311, by adding a new section 3677 establishing Jah'niqua's law. If enacted, Jah'niqua's law would require a defendant to pay restitution in the form of child maintenance if the victim of an offense was the parent or guardian of a minor child or dependent, and if the defendant was convicted of negligent homicide by means of a motor vehicle while under the influence of alcohol or drugs, a violation of 20 VI Code Section 504, or was convicted of driving under the influence of intoxicating liquors or controlled substances, a violation of 20 VI Code 493, which results in an accident that causes the victim to become disabled or totally and permanently disabled. Although we know that drinking and driving, or driving under the influence of any intoxicating substance, including drugs, is dangerous and can lead to death, it happens across the entire country and within the territory daily. It's estimated that 800 people are injured every day in the United States as a result of alcohol-related traffic accidents. Additionally, about 34 people die in drunk driving crashes daily. In 2023, more than 12,400 people died in alcohol-related crashes in the entire country. In the Virgin Islands, 20 Virgin Islands Code 493 makes it unlawful to drive while under the influence of intoxicating liquors or controlled substances and establishes penalties for violations. In addition, 20 VI Code Section 504 covers negligent homicide by means of motor vehicle, which provides a cause of action when the death of a person occurs within 1 year as a proximate result of injuries received by the operation of a vehicle by a person under the influence of alcohol or drugs. A person convicted of negligent homicide by means of a motor vehicle can be sentenced to imprisonment up to 5 years or a fine up to $1,000 or both. If approved, Bill number 36-0027 will direct Virgin Islands courts to order a defendant convicted of a violation of 20 Virgin Island Codes 504 or 493, which results in an accident that causes the victim to become disabled, to pay child maintenance if the victim is the parent or guardian of a minor child or dependent. Courts will be able to consider a number of factors when determining the amount of child maintenance to be paid, including the financial needs of the child, the financial resources of the disabled victim or surviving parent, the standard of living the child is accustomed to, and reasonable child care expenses. Child maintenance payments would last until the child is 18 years old or 19 if the child is still enrolled in high school. On April 13th, 2021, siblings Bentley and Mason lost their father, mother, and 4-month-old baby brother when their vehicle was rear-ended by a drunk driver in Missouri. This tragedy forced Bentley and Mason's grandmother, Cecilia Williams, into action and advocacy. In 2022, Bentley's law, a law requiring convicted drunken drivers to pay child support to children who lose one or more parents in a fatal accident, was introduced in Missouri. Although the legislation initially failed in Missouri, a handful of states, ultimately including Missouri, have since adopted some version of Bentley's law. Additionally, several states are currently considering similar laws. For instance, in Tennessee, quote, if a defendant is convicted of vehicular homicide due to intoxication or aggravated vehicular homicide, and the victim of the offense was the parent of a minor child, then the sentencing court must order the defendant to pay restitution in the form of child maintenance to each of the victim's children until each child reaches 18 years of age and has graduated from high school, end quote. So the financial needs of the child, the financial resources of the surviving parent, and the standard of living to which the child is accustomed to, the physical and emotional condition of the child and the child's educational needs, the child's physical and legal custody arrangements, and the reasonable work-related child care expenses of the surviving parent must be considered in Tennessee when deciding what amount of child maintenance is reasonable and necessary. Texas has a similar law requiring courts to order a defendant convicted of intoxication manslaughter or causing an accident while intoxicated that leads to the death of another to, quote, pay restitution for a child whose parent or guardian was the victim of the offense, end quote. Once again, courts in Texas must consider several factors when deciding what amount of restitution is reasonable and necessary, including the financial and educational needs of the child, the physical and emotional needs of the child, as well as the financial resources of the defendant. The laws in Tennessee and Texas are very similar to each other and to the proposed legislation. There's one major difference, however. The laws in Tennessee and Texas are limited to accidents resulting in death and do not include child maintenance payments for children of disabled victims. Mullaney's law, which was signed into law in Kentucky in April 2023, is almost identical to Section 1 of Bill number 36-0027. It allows restitution in the form of child support to be ordered in violation of Kentucky's driving under the influence law if the violation caused the death of a parent or guardian of a minor child or caused a parent or guardian of a minor child to be disabled. The Department of Justice supports Bill number 36-0027. Bill number 0027, or Jah'niqua's law, is in line with other laws that address the financial burden on the families of drunk driving victims, both disabled and deceased. Intoxicated drivers must be held accountable and should take responsibility for their actions. Bill number 36-0027 creates an avenue by which the Virgin Islands can force offenders to financially support the minor children of victims disabled or killed by drivers under the influence of drugs or alcohol. I thank the committee for allowing the Department of Justice to testify on Bill number 36-0027. This concludes my formal remarks, and I respectfully welcome any questions this body might have. Thank you.
Thank you for your testimony. We have Mr. Frank Harris. I have another testifier.
Yeah, point of information.
Senator Gittins, you recognize for point of information. We have a next testifier.
Just so that,
okay.
Yes, but just so the legislative record could be straight, that bill number is 36-0027 and not 36-0027. It's 0027. Thank you.
I stand corrected.
I have Mr. Frank Harris, Director of Governmental Affairs, Mothers Against Drunk Driving.
Yes, thank you, Mr. Chairman, members of the committee. My name is Frank Harris. I'm the Director of State Government Affairs for Mothers Against Drunk Driving. I'm based out of our national office.
Hold on a second, Mr. Okay, no, go ahead.
You want me to hold on? Okay. Well, I'll start again. Thank you again, Mr. Chairman, members of the committee.
Could you hold on a second, Frank? Okay. You go ahead now. Go right ahead.
I'll reset. Thank you, Mr. Chairman and members of committee. My name is Frank Harris. I'm the Director of State Government Affairs for Mothers Against Drunk Driving. I'm based out of MADD's national office in our Government Affairs Department. For the last 17 years, I have worked throughout the United States in pushing DUI reform alongside victims, survivors, and other supporters of MADD. MADD thanks Senator Gittins for authoring this proposal. And I really appreciate this committee and you, Mr. Chairman, for allowing MADD the opportunity to testify remotely. You know, it was raised before by the Attorney General that even in 2023, over 12,400 people are killed in drunk driving crashes. This is 45 years after MAD was formed in 1980. So drunk driving is still a prevalent, violent crime. And since COVID, since 2019, we've seen a 22% increase in drunk driving and deaths. So that is to say, the battle against drunk driving, as well as other forms of impaired driving, which includes negligent driving, is far from over. Which is why, we have been big cheerleaders of the efforts called Bentley's Law, which mirrors Jah'niqua's law throughout the United States. We have helped advocate for the passage of this in every single state. And it is really needed just to show that, first of all, the battle against impaired driving is far from over. And just to remind the public to never drive impaired. And, MAD is at first and foremost, we're a victim services organization. And, this is a great way for victims of impaired driving to seek justice. Because insurance coverage usually doesn't pay off enough to provide any type of restitution to care for raising your grandchildren. And in Cecilia's case, that is the case as well. Cecilia Williams in Missouri, who came up with this idea after her son and one of her grandchilds and her incoming daughter-in-law were killed by suspected by a drunk driver in 2021. And it was mentioned, this has been, and again, I've been in MAD for a while. This is one of the most organic grassroots movements I've seen that started in Missouri and has spread throughout the world, reaching as far as Korea and Guam. And we're actually up to now 7 states that have enacted laws like this. And, it was referenced Tennessee, Kentucky, Texas, and actually Maine, South Dakota, Utah, and just last month, Montana enacted laws like this. And the Cayman Islands actually enacted a similar law that also includes negligent driving cases last year. Again, the reason why I'm mad, we're really, this isn't necessarily going to be a preventative tool. It will serve as a reminder for folks not to drink and drive or drive dangerously. But again, it is another avenue, another pathway for victims to seek restitution and justice following an impaired driving crash, because the rights of victims even today are very limited in terms of either A, seeking justice, making sure somebody actually serves time incarcerated for killing somebody or seriously injuring somebody, or even on the flip side, to providing some resemblance so that they can go on with their life in some level of comfortability that is possible. So, I just wanted to note that, Matt has helped advocate for the passage of this based on a theory that this restitution, this child maintenance should be available. And we found out that in Tennessee, there's actually been 3 cases where the courts have figured out how to do this. And I included in my testimony just a transcript, or not a transcript, but just information I received from a victim survivor in Tennessee on what they had to go through to obtain these payments. But again, thank you, Mr. Chairman, members of the committee. Mothers Against Drunk Driving firmly supports this proposal, as we do in every single jurisdiction in the United States and throughout the world that seeks to propose this. And we really urge this committee's support, and happy to answer any questions. Thank you.
Thank you. Colleagues, we'll be having a 3-minute round. Recognizing Senator Bolkes, Jr.
Thank you, Mr. Chair, and good afternoon, Mr. Chair. Good afternoon, colleagues, and of course, good afternoon to the testifying panel here today. I want to start off by mentioning that this is a good piece of legislation. I know that there are some parts of the nation that, as mentioned in the testimony of the Attorney General. And I do have an amendment. I've spoken to the primary sponsor about the amendment. I'm looking forward to bringing that amendment to the bill as well. It's not coming today, but it will be proposed later. What I want to say is the law mentions, Attorney General, the law mentions that payments should be monitored in the same framework as civil case payments. Which agency or office will be tasked with monitoring those enforcing payments? Yeah, Attorney General.
Interesting question, and one that I've been thinking about. Obviously, since it's child support, one that comes to mind would be the Justice Department with its PCSD division, the Child Support Division. But I checked into that, and that division is a result of Title IV, Section D of the Social Security Act, and it's predominantly funded by the federal government. And to undertake that function does not appear to be consistent with its mandate under the Social Security Act. Other possibilities would be the Department of Health and Human Services. That might be a reasonable one because they do deal with those sorts of things. In a civil case, again, a court would take a look at let's say the civil suit was brought by the survivors. An amount would be determined by the court that would consider all the variables that we discussed in our testimony, and then would also appoint perhaps a guardian or a third party to oversee. So there's a lot of different options, and I don't have a specific answer right at this stage, but I would be glad to spend some time pondering it and share it with you.
I appreciate the feedback. That's one of the things I was pondering on, because we need to figure out where we're going to collect, and then of course,
right,
what is going to be. We know where it's going to go, but we need to figure out how we're going to collect. When the courts determine when a convicted offender, based on the merits of the case, I suppose, how do they figure out? Because someone could be incarcerated and unable to pay at the time, but I suppose after their release, then they would be required to pay, and then we need to figure out their financial situation at that time and the ability to make restitution payments.
Yes, that's correct. And as I mentioned in my testimony, there's a series of factors that the court is going to have to consider, and that's one of them. If someone's incarcerated, they may or may not have the capacity to pay. But if obviously, in most cases, it would be much harder. And the child, of course, needs the support right away. So there may be some requirements imposed by the court that you sell property or do things like that to raise the funds in order to make the payment quickly. But again, the court would have to sort through that. It'll be different in every case.
Duly noted. And Mr. Chair, if I might just quickly wrap up, please.
Yes, wrap up.
Thank you, Mr. Chair. In situations like this, lives can't be replaced, and of course, when children are involved, a mother or father passes away abruptly, especially in a case like this. This measure does put something in place that there is some sort of continuity or a future, because we all have responsibilities as parents, and when a parent is taken away, then a child is left behind. So I want to commend the bill sponsor on this measure and look forward to assisting with working on it as well. Thank you, Mr. Chair.
Thank you, Senator. Mr. Harris, are you online?
Mr. Chairman, yes, I am.
Yes, the question I have for you is, how does other states collect their money?
Well, again, the state that we have an example of
is Tennessee, which was collected via the court process. And, we're still gathering more information on how exactly that information, how that payment is submitted to the family each month. And I could look into I could check back with the victim survivor just to see that. But short answer is it's through the current court process. I don't believe that money will deduct it from the offender's paycheck or anything of that nature, but I could look into that and get back to you.
Yeah, do that. Thank you.
Because I know in other states, the big concern we've heard is like, well, what court is this going to go through? Is it a criminal court? Is it a civil court? Is it a family court? But in Tennessee, it's just, it wasn't a family court.
Thank you.
Thank you.
I recognize Senator Avery Lewis for your 3 minutes.
Thank you, Mr. Chairman. Thank you. Good afternoon, testifiers. Good afternoon, people of the Virgin Islands, and again, good afternoon to my colleagues. Attorney General Ray. How will this restitution interact with existing child support statutes in the Virgin Islands Code?
Yeah. Again, there's an obligation for parents and guardians to take care of a child. And what this does is it steps in when the parent-guardian situation has been disrupted by death or disabling injury. And at that stage, once that happens, I agree with Mr. Harris. It makes sense for the court to go ahead and issue an order that will set out what needs to be paid. The court will have to look at the various variables and determine how that's possible to be done. As I mentioned, obviously, if the offender is incarcerated, it may be more difficult to get the funds, and getting the funds right away is critical. Ordinarily, someone files a civil action for the child, but in our court system today, that can take literally years before the funds would come, and by that point, it's too late. So I think it makes sense for the court that's handling the sentencing to go ahead and put into place a system for the payments.
Thank you. Does the Department of Justice plans to support public education about the Jah'niqua's law as a deterrent and accountability tool?
Yes.
All right. In comparison to other jurisdictions, I looked this up. In Tennessee and Texas, they limit their laws to fatality cases.
Mm-hmm.
Does the Department of Justice support the inclusion of disabled victims in the Virgin Islands version?
Yes. Again, you can have someone who is responsible for their child, be it a parent or a guardian, and if they're disabled and unable to make the funds to handle the payments, it's as though they were dead as far as the child's upkeep and care is concerned. So yes, we would definitely support that addition.
And currently, are there any mechanisms or proposed mechanisms in place to ensure compliance once a defendant is released and resumes payments? Will wages be garnished or license suspension be tools to consider for non-compliance?
Yes, those would make sense. And also, since it's going to be a court order, if they don't pay, they could be held in contempt by the court. So they're looking at some severe penalties if they don't comply.
Ms. O'Neill, good afternoon. Does the VIPD envision any role for government or community agencies in supporting affected children or families until restitution begins, or if it cannot be collected at all?
Good afternoon. I will defer that question to Acting Commissioner Santos.
All right. I was the chief again, sorry. AC Santos, you want me to repeat it, or did you hear it?
Yes, Senator, please.
I asked, does the VIPD envision any role for government or community agencies in supporting affected children or families until restitution begins, or if it cannot be collected at all?
If we support it, Senator?
Yeah, I mean, well, if
that's the question?
Yeah, if we can't get them to pay, do we see any role where outside help or even the government stepping up?
Oh, definitely. I don't see why, in my opinion, I don't see why the judicial system won't be able to assist us in whether it be garnish of wages or property in lieu of, or to be converted into finances to aid in that effort.
All right, I think we're going to expound on that a little more in another round. Thank you, Chief. Assistant Commissioner Santos. Sorry.
No problem.
Thank you, Senator. At this time, I'd like to acknowledge.
Point of information.
Point of information. Senator Gittins, you recognize. Oh.
No, Senator Bolkes.
Okay, Senator Bolkes, you recognize. Point of information.
Yes, thank you. Thank you, Mr. Chair. Concerning the housing of the collections, if I can term it that way, to Attorney General Ray. In essence, this process is very, very similar to the child support process. And in essence, this bill seeks to provide child support for a child with an individual who is not their biological parent. Obviously, the act was done, and based on this law, when it passes, or if it passes, that individual, he or she, would be responsible for the restitution. So, is there any law that's prohibiting by an individual who is not a biological parent from providing restitution? Because if not, then I don't see why it can't be done through the child support division.
Well, there's no law that prevents a child who's lost parents or other support from obviously bringing a civil action or someone bringing it on their behalf in order to collect the funds. There's none like that. As far as whether or not, well, I don't know how that impacts what division would need to handle it in the government. It seems to me, and again, we need to think about this and talk it through. And I'd like to check with some more people who have more background in this specific area than I do. But I can tell you in a civil case, a court would end up issuing an order that would set out the requirements for payment and to who it went to and how it would be, how the child would be covered. And it seems to me that in this case, that makes a lot of sense as well. Again, as I mentioned, our PCSD division in the Department of Justice, this specific type of thing is just not covered in their federal legislation and mandate under the Social Security Act, which is the basis for their existence.
It seems to me that the Division of Child Support seems to be the best suited place for these types of collections. Thank you for the time, Mr. Chair.
Yes, sir.
Senator Lewis, you're recognized for your point of information.
All right, Attorney General Ray, does the judiciary currently have the administrative resources like staffing systems to track, collect, and remit court-ordered child maintenance payments, like would be stated under this bill?
Well, we need to check with the courts on that, but they do, obviously, in a lot of civil cases, order things just like this, which is payments of funds, and if the payments aren't made, then they have their means of enforcement.
I ask that because I know this would be an additional something new, so I'm just wondering if, you know, if they'll be able to handle it, if they'll tell me something about staffing or whatever. But you may not be, go ahead.
I was going to say, it's not that much different from what they already do in a lot of cases, including injury cases. If there's an injury case, an order is generally issued at the end of the case if liability is found, that the defendant has to pay certain amounts and schedules could be set up, but that has to be done. Normally what happens is if the payments aren't made, then the recipient or intended recipient complains to the court, and the court then issues an order to show cause, and there's a hearing on it. And so it would be, that process already exists, and this seems to be sort of tailor-made for that same process.
All right, thank you very much for your response.
Yes, sir.
Senator Johnson, you're recognized for your 3 minutes.
Good morning. Thank you very good afternoon. Thank you very much, Mr. Chair. Good afternoon to the testifiers. Good afternoon to my colleagues. I want to ask Attorney General a few questions. One of them is, how does this bill ensure that the restitution order does not infringe on defendants' constitutional protection, such as double jeopardy, while still allowing victims to pursue separate civil recovery against other liability parties?
Right. That's an interesting question, and I was thinking about that myself. If the victim receives this, then can the victim then also proceed civilly? And as I sit here right now, don't know the full answer to that. I can see the problem, but I can also see that the victim might have other remedies that are beyond just the monetary remedy that's envisioned here. So I'd be glad to look into it and get back to the committee.
I think those are minor things that can be tweaked, and I see whereby we need to look at it carefully and make sure that we address it. And then my next question would be, the bill lists factors the court must consider when determining child maintenance amount. Should the legislation provide more concrete guidelines or caps to ensure consistency for the families?
Well,
same time fairness?
I think the problem is every case is going to be very different, both in the capacity of the offender to pay certain amounts, also the amount of that the child requires. That list of factors that I mentioned in my testimony is going to vary. So I think it's fair enough to leave that up to the discretion of the court to look at all the variables and say, here's the amount that's going to be fair in this case.
And I think that's why my previous colleague was speaking in law of child and paternity with handling it based on, they have the configuration as to, based on income, how much can that individual afford to pay in sense of child support. If someone was to go to court for child support, you look at their income and also look at their responsibility as far as rent, their way of living, and then you come to that particular factor. And that's why I do support probably going through child and paternity, because they have all of these configuration of the cost and also not putting a burden to have that individual not be able to live their life too, because then it comes to a point of not being able to collect. And then that's where my next question will be, in cases where the convicted offender lacks financial means or long-term earning potential,
Time.
how will the courts ensure that the restitution orders are enforceable? And that's why I say with child support, they normally have a chart based on the child's needs to survive, and also look at which would have been the parent income, and based on that, then they will come to that configuration for a figure. So I support this measure. I just think there's some little minor tweaks that we might need to do to assure that that child get taken care of, but at the same time, not to create hardship that person don't do their duties and fulfill the obligation, because again, it will need some more tighten of screws. If an example with Mr. Chair, may I just wrap up on this?
Yes, you may.
In a case with child paternity, well, I haven't seen one of them in a long time. Normally when a parent doesn't support their child, sometimes they have been put in prison. So I haven't seen that in a while. That's what I said. Child and paternity do have these measures. I guess sometimes it reaches to the court to make that decision. So there's a couple little things I think we need to do, but I do support this measure, and I hope that we sure can tweak it that little bit and move it forward so that it can definitely take care of those children. And in the case with those that are disabled, that can't, that was disabled in the accident and can't take care of their child, that they do get that benefit too. Thank you very much, Mr. Chair.
Thank you. Chair recognizes Senator Fonseca for your 3 minutes.
Thank you, Mr. Chair, and pleasant good afternoon to all the listening audience. So I'm definitely in support of Bill number 360027, requiring restitution in the form of child maintenance payments from individuals convicted of driving under the influence. And it also would provide financial stability to children left vulnerable by the DUI-related tragedies, ensuring that the child is able to, live to a similar capacity before, and it applies to also the disabled. I wanted to ask Mr. Harris, I had a couple questions for you. What state are you in?
I live in Northern Virginia.
In Virginia. Okay, so what is the blood alcohol concentration limit in your state?
It is 0.08 is the legal per se level.
Okay.
As it is here.
And I'd like to ask Attorney General Gordon Ray, what is the BAC limit in the Virgin Islands?
I don't know.
Okay.
I've never looked at that myself.
It seems like, in the United States, it's more or less, most states have the 0.08%. I was just concerned if the Virgin Islands had the same 0.08%. And then let me ask you, Mr. Harris, for the drivers under age 21, is it a zero tolerance? In other words, it doesn't matter what percent of alcohol in the blood. What is it in your state?
Mr. Chairman and Senator, it is technically zero tolerance. It's at 0.02. It is the level.
Okay.
Yes.
And then, Gordon Ray, do we have a zero tolerance for the blood alcohol for drivers under 21 in the Virgin Islands?
Again, I don't know. I've been practicing here for more than 40 years, but I've never handled a drunk driving case.
Okay.
And I just don't know. I can find out very quickly for you.
Okay. Yes, I'd like to know that. But I'm definitely in favor of the bill because in the Virgin Islands, I think we have, I don't want to say that it's lax alcohol laws, but I know in certain states, you can't be drinking, you can't be seen with the beer bottle in the car driving around. And in the Virgin Islands, people do it all the time. So I think we're kind of lax, and I am definitely in favor of this. Let me ask you one question, Mr. Chair, if I can wrap up. Mr. Harris, are there enhanced penalties in your states for those drivers that have a higher percentage, say 20% alcohol or above, or it's the same as those with the 8%?
Mr. Chairman, Senator, yes, there are enhanced penalties for certain offenders, but impaired driving is impaired driving.
Okay. And then Attorney General, do you know if we have the enhanced penalties in the Virgin Islands?
Again, I don't know. I'm just not familiar with that specific area. I'll be glad to get the answer for you, though.
Well, I'm in favor of the bill, and I think that those are possibly some areas that we can have some amendments to include the percentage of the BAC, and also to have the drivers under 21, if we want to look at the zero tolerance for under 21, and also for the enhanced penalties for those with the alcohol limit over 15%. That would put us more in line with the national averages. And I definitely support this legislation, and thank you so kindly, Mr. Chairman, for the time.
Point of information.
Point of information.
Senator Lewis.
Thank you, Mr. Chairman. Attorney Ray.
Yes, sir.
I have need some clarity. If someone was to commit a crime by violence, let's say murder, they shoot someone, they go to court, the judge sentences them for 20 years, and they complete their time, and they come out, can they be sued as well? Like what's, because I'm trying to see where's the, like the correspondence, the relation to this here. Because one is a malicious act and one might be still considered an accident. But just help me, because I know people out there probably are listening and wondering the same thing.
Sure, and we have a statute of limitations for filing civil lawsuits. So if it's 20 years later, that's definitely well past the time frame in which you can file a lawsuit. So if the injured party can't wait until the end of the entire judicial process before filing, assuming the judicial process runs longer than 2 or 3 years.
Okay.
It seems to me that the proposed legislation takes care of that problem, because in many ways it's sort of a substitute for the civil action, because it's getting the support to the child right now.
I understand. If the proposed legislation now, if you commit an act of, you take a parent away from a child, we compelling you now to really take care of that child, because you took the parent away, the guardian, the loved one from that child. I got that, but I was just trying to clarify on the next side, what's the restitution for that?
Right. And if there's additional losses such as pain, suffering, all of that kind of thing, emotional loss, that may well require a separate civil suit, and that would have to be brought within the time frame for bringing those kinds of suits, which generally is going to be about either 2 or 3 years, probably 2 years because of the tort rules.
All right, thank you for that clarity. Thank you, Mr. Chairman.
Point of information.
Point of information, you recognize Senator Gittins.
Thank you, Mr. Chair. I wanted to respond also to the inquiry from my colleague from Frederickson regarding the measure that the measure would prevent the families from being able to pursue a civil matter. What this bill seeks to create is a court-ordered child maintenance obligation as part of the criminal sentencing process. So therefore, they will still have that right to file the matter civilly.
Right. Thank you. I recognize the mic of Senator Noble Francis Jr. for 3 minutes.
Thank you very much, Mr. Chairman, and good afternoon to everyone. I want to commend the bill sponsor in moving this very important piece of legislation, as your DUI, based on the statistics that have been provided here today, seems to be staggering, and there seems to be an increase in it. I wanted to ask you, Ms. O'Neill, in comparison to previous years, are we seeing an increase in DUI and impaired driving situation?
Daphne O'Neill, Office of Highway Safety. Yes, we are.
So that brings me to again, the enforcement of it. What's happening in the space of enforcement? I'd like to ask the Virgin Islands Police Department, what is the level of enforcement? Because if we could avoid, if we could prevent these situations from occurring, because there's nothing that we could do to replace life. What is being done in terms of enforcement with these staggering statistics that we're seeing in comparison to year data?
Assistant Commissioner Santos. Yes, Senator, we continue our efforts in our DUI initiatives. They are more especially ramped up around our holiday seasons. No matter which holiday we know that's coming up, we ensure to ramp those up territorially to ensure the safety of the community and the motoring public.
Thank you for that. And the more we can do, the better it can be for us. Let's try to prevent life rather than trying to deal with Jah'niqua's law at the back end of it. In regards, again, to look at your statistics, are we seeing, I know that the age back in my days used to be 70, I think it was like about 65 and above when we were seeing DUI arrests and those type of, is that still the number, or are we seeing a variation of that now?
Regarding Daphne O'Neill, regarding DUI arrests, unfortunately, they're trending downward. We had a total of 88 in 2020, and thus far for 2025, we've had 45.
And what's the age range? I'm trying to focus in on the age range in those arrests. You have that stats?
Unfortunately, I don't have that, but I can get it for you.
Okay. And like I said, I remember back in the days, it used to be on the upper end of the age scale, but I was just trying to find out. Attorney General Ray, the report that I'm receiving that there seems to be some double standard as it pertains to DUI arrests in the Virgin Islands. We're hearing that the transients and visitors are able to escape, elude, get away, get released or whatever in these cases not being filed against them. Have you been able to determine any such situation?
I'm not aware of that situation. Again, I can check with our criminal division that handles those and find out if that indeed is the case.
Yeah, let's take a look at that because, again, I'm getting information that individuals that may be involved in DUI, that may be transient visitors, Caucasian individuals get released and get to go back to the States, and there is no further prostitution allowed on those cases, while the other local cases are, of course, being enforced. So I think we need to get a handle of that if, in fact, that is occurring.
I will definitely look into it.
From what I'm hearing, again, there seems to be some work to make a determination of exactly who will be responsible for the collection of the fund as well as the disbursement. I think that the system that the child support have might be the best system. Of course, the court could mandate what that amount will be, and I think that seems to be the way to go on this. You're saying that the software or the child support is unable to do that at AG?
No, I think there may be a legal problem with it doing that because its mandate is under the Social Security Act, which spells out what it can do. And there are some real issues as to whether it can handle that. But again, I will look into that more in depth. And I think it is a very important issue to figure out exactly who is going to administer this, particularly since it's going to be automatic. At least once a judge has declared what the amount will be and what the payment schedule will be, et cetera. Yes, we do have to have an agency that can monitor that and that the child can go to if the payments are not forthcoming. And I think we need to look into that. It's not covered in the proposed legislation, but I think it's a critical factor.
Okay, and the gentleman from MAD, Harris, Mr. Harris, good afternoon, welcome. You still online?
Yes, Mr. Chairman. Hi, Senator. I'm here.
Do we have an active MAD component here in the Virgin Islands? I know that they used to be active some years ago. Are they still active?
I asked when I was invited to testify here if there was, and at this point, the short answer is no, we don't, but we're always looking for volunteers.
Yeah, okay. I'm hoping that we could get that back going. That was very effective back in my days when I was with the Virgin Islands Police Department. Again, I think this is good legislation, and I am not a member of this committee, and I don't have a vote in this committee, but it's something that I truly believe that should be supported. But the most important thing for me is, again, enforcement. Let's try to minimize dealing with this situation on the back end. And let's address the issue of enforcement and making sure that we stop the amount of DUI that we're seeing that lead to these vehicle deaths. Thank you very much. And again, congrats to the chair and the bill sponsor and this piece of legislation. I think it's good legislation. Thank you.
Thank you, Senator Francis. The committee will be taking a two-minute recess. The committee is back. The committee is back on record. We now recognize Senator DeGraff for your 3 minutes.
Thank you, Mr. Chair. Good afternoon, colleagues. Good afternoon, testifiers, all of you listening and present. This is, I support this legislation, but Attorney General, I heard you saying that this legislation addresses the child maintenance automatically, but the bill doesn't say that, though.
No, and if I said that, didn't mean to. By that, I meant it sets up a system so that a court can determine how much the child should be paid.
Okay, but even that I didn't see. I didn't see what the system is because, again, we're trying to contemplate whether it should be under child support. Or, in other words, it's based on I'm in an accident, I get disabled, I can file for civil action. Does that take away from this bill?
Doesn't take away from it, no. This bill actually speeds a lot of the important part of that process up. It says the parent's gone, and so the offender is going to be required to pay child support, and then it has to determine what is the child support. And that is the variable that will take account of all the different needs of the child, and they'll also have to look at the ability of the offender to pay.
Okay, so then,
and the child, and on behalf of the child, a civil action could still be brought.
So should there be a scale in terms of a mandatory minimum that should be paid maybe upfront?
Well, I mean, that would be possible. Again, it's going to turn on the capacity of the offender to pay and the need of the child.
Okay, so right now as it stands, without this bill, what happens in a civil action?
Civil action would be brought. The attorney for the child would be presenting to the court evidence about what the damage to the child has been, how much it needs by way of support, and also how much it should be compensated for its loss of parent, for its emotional damage and all of that. And so the civil action would look at a lot more variables than just what this bill looks at, which is the physical money support. But that's one of the things that the court would look at in a civil action as well.
Right, so again, so then what does this bill, because I'm wondering if it becomes a duplication.
Well, not really. No? Okay. I'm sure in a civil action, if someone is also paying under this bill, that the amount that they're paying under the bill would be taken into account in determining how much more they would have to pay in the civil case.
Okay, and in closing, if I may, Mr. Chair, okay, in section 1(6)(f), if a defendant who has been ordered to pay child maintenance is incarcerated and unable to pay, the defendant has not more than 1 year after the release from incarceration to begin payment, including entering into a payment plan with the clerk of the court to pay any arrearages. That specifically speaks to the clerk of the court. So then, is this what would also be in a civil action?
In a civil action, that's probably the way that it would run, yes. The court, if there's a violation or failure to pay, then there would be a action brought for contempt, and then the court would take whatever, action would be appropriate.
Okay, so you're in support of the bill?
Yes.
Okay,
Yes.
thank you. Thank you for the time, Mr. Chair.
Thank you. Point of information, Senator Fonseca.
Yes, Attorney General, one thing I would like to, for you to look at when you're doing the research, right, is that the commercial drivers, it seems like the federal standard for the blood alcohol level for them is even more stringent. And, particularly those commercial drivers that operate those heavy vehicles. And from time to time, you see them on our roads. They're driving above the speed limit. And those are potentially dangerous situations because those big, large machines can't stop too quickly. So I think that we should adopt the federal model, if we haven't already, so that the commercial drivers have a tougher requirement than the normal drivers. And now all DUI is dangerous, but the commercial drivers are even more so. Those concrete trucks, and all those heavy equipment. So thank you, Mr. Chair, for the time.
Thank you. The chair recognizes Senator Gittins for your 3 minutes.
Thank you.
Hold on a second. Hold on a second. Sorry, I want to recognize the President, Senator Alma Heiliger Francis, and also allow her a point of information before you speak, since you're the bill sponsor.
Thank you.
Okay, she actually have the time. Thank you.
Oh,
thank you.
Thank you so much. I just quickly wanted to get a little bit of clarity in regards to is it automatic that this kicks in if somebody is negligent versus is it a possibility we could write it or amend it in a way where the guardian or the parent or someone has an option to decide if they want to go civil versus utilizing the mandatory option? Because I'm a little bit concerned that we make this mandatory and then that person turns around and sues them again, and then you have double jeopardy for the same identical situation. That is where I think my concern is, just listening to this conversation, and I think we as a body, how it's written, might need to clear that part up. But what are your thoughts as opposed to having it just mandatory versus someone getting the option to decide? Explain that to me.
Well, Gordon Ray, the Attorney General, again, I favor the legislation because I know how long it can take for civil courts to actually get a result. And if you're talking about a child, each day is important, each year is important, so you want to get money moved to the child as quickly as possible. And this seems like a fair way to do it fairly quickly because it says if you harm the parent or guardian of the child, and so there's nobody available to make the payments, obviously you've got to do it. Mm-hmm. And a court figures out what those payments should be, and they're ordered to do it. If it went the civil route, it would take a long time to get there, just because of the nature of calendars.
Is there a way, because again, I don't want double jeopardy for the same thing. Mm-hmm. Is there a way for us to say, well, okay, it's mandatory, but then in our law, you can't turn around and sue civilly because you're already getting restitution for the same identical thing. I need to make sure that we don't double up on the same individual for a situation.
Time.
My off-the-cuff analysis is there's really no double jeopardy here because double jeopardy means you can't be tried criminally
twice for the
same thing. But the civil action would not be a criminal action.
Okay.
And so
I know what double jeopardy means, and I was just tossing out the phrase just to make you understand. I mean twice.
Okay.
But at the end of the day, I am not going to set easy knowing that you could go after the same person twice for the same thing. Because if they already went through the judicial system and they're found criminally negligent, that's one thing. And then from a restitution standpoint, you have to support the child. Then you still leave the doorway open to sue them civilly, maybe for the same child. Something is off here, and that's where my concern is. But I want to thank Mr. Chair for giving me the time. Thank you.
Okay.
Thank you. Senator Gittins, you're recognized for your 3 minutes.
Can I get a quick point of information first, based on the last speaker?
Yes, you can.
Thank you.
Point of
I want to, I'm happy that the Attorney General made it clear that this will not be considered a matter of double jeopardy. And I want to also remind folks of the O.J. Simpson case, wherein while he might have beaten the criminal charges one way, he was still held civilly liable. And again, this measure would not prevent the families from pursuing civil matters. There's a difference between the criminal accountability and the civil accountability. In this case, this measure seeks to just address the criminal accountability in this matter. And like the Attorney General said, every day is critical in that child's maintenance. That's my point of information. Now, let me read something from, I think it was April 23rd, 2023. And I think it's the St. Thomas source. A 27-year-old woman is dead and 2 others injured after a head-on collision early Sunday on Northside Road on St. Croix, the VIPD reported. Police were alerted to the accident in the vicinity of Blues Backyard Barbecue and Grill around about 3:35 a.m. on Sunday. This idea didn't come from a policy think tank. It actually came from one of my team members in the office, where one of my employees experienced firsthand the devastation of losing a dear friend of hers, Jah'niqua, in a tragic crash on St. Croix, again on April 23rd, 2023. It was alleged that the driver may have been under the influence, but for reasons that are still painful and frustrating, DOI charges were not levied. But the driver, however, was charged with negligent homicide by means of a vehicle, reckless endangerment, and involuntary manslaughter. You know, we found that even when someone is not charged with DUI, but is still found guilty of reckless or negligent driving that leads to such a tragedy, there are few, if any, tools for the system to support surviving children long term. This bill aims to change that. It sends a clear message. If your choices behind the wheel rob a child of their parent, you will be held accountable. Short. Not just in the courtroom, but also in your responsibility to help care for the life that you help to actually alter. I'm encouraged today that we're not standing alone in this effort, and it is a strong and significant step towards actually having the Attorney General's office and the Virgin Islands Police Department here to testify in support of this measure. Even more important is the fact that the Division of Paternity and Child Support sits or operates under the authority of the Attorney General's office. And this office, the Paternity and Child Support, is already equipped to handle these types of obligations. Because of this existing structure, the courts can actually direct the child maintenance payments orders under this law be paid through the Division of Paternity and Child Support. This ensures consistency, transparency, and enforcement using the systems already set in place. It means that this bill can be implemented swiftly and that children will receive the support they deserve within minimal bureaucratic delay. Again, the same thing that the Attorney General just spoke of. And we need to just send a clear message. If your actions on the road take a parent away from the child, our justice system will not look away to the next side. Accountability doesn't end with a conviction. It must extend to the lives left behind that is now suffering. And on that note, I want to bid condolences to Joan Felix, the mom of Jah'niqua, and the dad, Stedroy Williams, and all who have lost a loved one to the hands of someone driving either under the influence or driving negligently or recklessly on the roadways. And yes, this does also, negligence also include those driving and texting, driving and using your telephone while on the road, and injuring someone and thereafter them losing their life. I thank you all, colleagues, and ask you to please consider this piece of legislation closely. And I thank the at-large senator and embrace the amendment that he is about to offer regarding even those children who might be disabled. Thank you, Mr. Chair.
Thank you. I too support this legislation. I must continue to encourage individuals to be responsible. At this time, do I hear a motion?
Absolutely, absolutely. Motion.
Motion by Senator Gittins.
Mr. Chair, colleagues, I move that Bill number 36-0027, an act amending Title 5, Virgin Islands Code, Subtitle 3, Part 1, Chapter 311 by enacting Jah'niqua's law, requiring a defendant to pay restitution in the form of child maintenance if the victim of the offense was the parent or guardian of a minor child or dependent, and if the defendant was convicted of negligent homicide by means of a vehicle, a violation of Title 20, Virgin Islands Code, Section 504, while under the influence of or affected by intoxicating liquor or narcotic drugs, or was convicted of driving under the influence of intoxicating liquors or controlled substances, a violation of Title 20, Virgin Islands Code, Section 493, which results in an accident that causes the victim to become disabled or totally and permanently disabled, be voted upon favorably here in this committee and be forwarded to the Rules and Judiciary Committee for further vetting and action. I so move.
Bill number 36-0027 has been moved by Senator Gittins, second by Senator Fonseca, DeGraff, and Senator Franklin Johnson. And Senator Angel Bolquez Jr. Roll call, please.
Senator Angel Bolquez Jr.
Yay.
Senator Bolquez, yes. Senator Dwayne M. DeGraff.
Yes.
Senator DeGraff, yes. Senator Ray Fonseca.
Yay.
Senator Fonseca, yes. Senator Kenneth L. Gittins.
Yes.
Senator Gittins, yes. Senator Franklin D. Johnson. Senator Johnson, not voting.
Said yes.
Oh, me here. Sorry. Senator Johnson, yes. Senator Avery L. Lewis.
Yes.
Senator Lewis, yes. Senator Clifford A. Joseph.
Yes.
Senator Joseph, yes. Mr. Chair, you have 7 yes.
Bill number 36.002, an act amending 27, sorry. Bill number 36.0027, an act amending Title 5, Virgin Islands Code subtitle 3, Part 1, Chapter 311, by enacting Jah'niqua law, requiring defendant to pay restitution in the form of a child maintenance if the victim of the offense was a parent or guardian of a minor child or dependent, and if the defendant was convicted of a negligent homicide by means of a motor vehicle. A violation of Title 20, Virgin Islands Code, Section 504, while under the influence of an affected by intoxicated liquor or narcotic drugs, or was convicted of driving under the influence of an intoxicated liquor or controlled substance, a violation of Title 20, Virgin Islands Code, Section 493, which results in an accident that causes the victim to become disabled or totally permanently disabled, has been approved by the Committee on Homeland Security, Justice, Public Safety, and will be forwarded to the Committee on Rules and Judiciary for the consideration.
Point of personal privilege.
Recognize Senator Gittin for point of personal privilege.
Thank you. I want to extend my heartfelt thanks and gratitude on behalf of my staff and I to all the testifiers that came today to testify on this measure, and even those that wanted to come but was unable to. And at the same time, I want to really stress to the motoring public to please drive as safely as you can. The road belongs to everyone, and we just need to simply be cognizant of what we're doing. The constant use of cell phones and texting and talking and driving is a distraction. Even putting on makeup and eating, rushing to work early in the morning and eating your breakfast while driving. We got to be careful that our consequences, or our actions, will lead to serious consequences. So again, thank you to the Attorney General's office, the Virgin Islands Police Department, Office of Highway Safety, and the good gentleman from MAD. I hope my staff wasn't too aggressive in trying to get you, but we're going to stay in touch with you because we would like to really reorganize that MAD organization here in the territory. Thank you to Mr. Chair, to you and your staff for putting this measure on so swiftly. Thank you. Thank you, colleagues.
Thank you. The Committee on Homeland Security, Justice, and Public Safety will take a 2-minute recess. The committee is back on record. Madam Clerk, please call up the third block of the agenda.
Bill number 360057, an act amending Title 5 Virgin Islands Code, Chapter 314, Section 3733, subsection A, to require automatic expungement of arrest record and complaint or information when the accused has been acquitted. Sponsored by Senator Alma Francis Heiliger. Invited testifiers, Honorable Mario M. Brooks, Commissioner, VI Police Department, Honorable Gordon Ray, Esquire, VI Attorney General, VI Department of Justice, Ms. Julie Smith Todman, Esquire, Chief Public Defender, VI Office of the Public Defender, Bill number 36-0024, an act amending Title 14, Virgin Islands Code, Chapter 85, by adding Section 1710, declaring a person incapable of consent to sexual relations while the person is in police custody. Sponsored by Senator Ray Fonseca. Invited testifiers, Honorable Mario M. Brooks, Commissioner, VI Police Department, Honorable Gordon Ray, Esquire, VI Attorney General, VI Department of Justice. Ms. Julie Smith Todman, Esquire, Chief Public Defender, VI Office of the Public Defender, Ms. Anya Stewart, Executive Director, Family Resource Center, Inc. Mr. Chair, that ends Block 3 of the agenda.
Who speaks to this bill? Number 36-0057?
I do.
You recognize Senator Alma Heiliger Francis. Francis Heiliger.
Thank you.
Motion.
You recognize for your motion?
Mr. Chair and colleagues, I move that we combine bills number 36-0057, 0024, and 0031 in this, consider them in this one block. I so move.
Second.
I agree.
No objection, so ordered. Hearing no objection.
It has to, you have to state properly move. Who's second?
Okay. Motion been made by Senator Gittins, second by Senator Fonseca, and to combine the last two blocks. So hearing no objection, so move.
To combine the last three items in this block.
It's two blocks. The last two blocks.
Yes, so we're combining all in this one block.
Agreed. That's what I said. So ordered. Okay. The committee will be taking a 2-minute recess.
All right, big brother. Thanks a million.
The committee is back on record. Madam Clerk, please call up the next item on the block, on the agenda.
Block 4, Bill number 360031, an act amending Title 23, Virgin Islands Code, Chapter 10, Subchapter 4, Section 1073, to exempt a public safety agency or private safety entity from liability for acts of negligence in the operation, administration, and maintenance of a 911 service unless the acts are committed in a grossly negligent manner or are committed with willful intent. Sponsored by Senator Alma Francis Heiliger. Invited testifiers, Honorable Gordon Ray Esquire, VI Attorney General, VI Department of Justice. Honorable Darrell Jashin, Director, Vitima. Mr. Chair, that ends Block 4 of the agenda.
Thank you. Who speaks to this bill, number 36-0031? 57.
I do.
Senator Francis Heiliger, you're recognized.
Thank you so much, Mr. Chair. Good day to my colleagues, good day to the testifiers, good day to the people of this territory and staff. I offer Bill number 360057, an act amending Title 5 Virgin Islands Code, Chapter 314, subsection 3733, Section A, to require automatic expungement for arrest records and complaint of or information when the accused has been acquitted. I offer this piece of legislation because as a representative of the people, I, not only between having conversations with individuals that have struggled with getting their record clear, but also listening to some of the testimony that has come forward here on this Senate floor over the past few years I have been here, I have come to the realization that this has been a cumbersome task for many who have already gone through a situation where they have been arrested, they have gone through a court case, they have been acquitted, which means that they are considered innocent according to our laws. But because of this arrest, all of this information is still stored with our government. The problem that comes up is every time you go and look for information, that information shows up. If they happen to have a traffic stop and somebody checks something, that information can show up. And I think this is an unfair situation for individuals that have already gone through the process, have already gone through the trials, and for them to have to continue to do this throughout their lifetime, it is highly unfair. Now, our Virgin Islands Code does allow for an expungement process, but that expungement process consists of individuals have to file petitions, they have to go through to judges, and only a judge could decide whether or not that they're going to grant their expungement. That is unfair. If I have gone through the trials, I've gone through the tribulations, I've gone through the arrest, and at the end of it, you tell me I am innocent of this, you should clear out my record. So I look forward to any discussion on this matter today. I look forward to any suggestions or recommendations from my colleagues or testifiers, but the time has come that people should not be begging for their record to be clear, especially when we as a society has told them they're innocent. Thank you very much, Mr. Chair.
Thank you, Senator. Who speaks to bill number 36-0024?
I do, Mr. Chair.
Senator Fonseca, you're recognized.
Thank you so kindly, Mr. Chair, and all my colleagues and the testifiers present. Today, I present for your deliberation and consideration Bill number 36-0024, an act amending Title 14 Virgin Islands Code, Chapter 85 by adding Section 1710 to declare a person incapable of consent to sexual relations while in police custody. This bill prohibits law enforcement officers from engaging in sexual conduct with individuals while they are detaining, arresting, or holding in custody, including during traffic stops or questioning pursuant to an investigation. Several states have already enacted these laws to prohibit this practice. And this bill is not about making assumptions, nor it is about targeting our law enforcement community, who are deeply respected and we rely on every day. This bill is about ensuring accountability, protecting human dignity, and upholding the integrity of our justice system. It recognizes a basic truth that power dynamics do matter. When someone is in custody, in handcuffs, or confined and dependent on the decision of a law enforcement officer, they are not in a position to give free and voluntary consent to sexual acts. There should be no gray area when it comes to power, coercion, and sexual exploitation across the country. States have already taken this important step to close this legal loophole that has allowed abuse to hide behind claims of consent. We in the Virgin Islands cannot allow a system to exist where someone in police custody can be taken advantage of and the perpetrator claims that it was consensual. This is not justice. That is not who we are. This legislation sends a clear message. If you are entrusted with the power to detain someone, you do not have the right to exploit them, period. Consent must be meaningful, and when a person is under arrest or in custody, the power imbalance that a law enforcement officer has must render any notion of sexual consent invalid. Bill number 36-0024 protects the vulnerable and also upholds the integrity of our legal institutions and reaffirms our collective commitment to justice, equity, and human decency. Mr. Chair and colleagues, I ask for your favorable consideration of Bill number 36-0024. Blessings.
Thank you, Senator Fonseca. Who speaks to Bill number 36-0031? I do. Senator Alma Francis Heiliger, you're recognized.
Thank you so much, Mr. Chair. Good afternoon to my colleagues. Good afternoon to the people of the territory. Good afternoon to the testifiers and staff. I offer Bill number 36-0031, an act amending Title 23, Virgin Islands Code, Chapter 10, Subchapter 4, Section 1073, to exempt a public safety agency or private safety entity from liability for acts of negligence in operation, administration, or maintenance of a 911 service unless the acts are committed in a grossly negligent manner or committed with willful intent. This piece of legislation seeks to protect those that are in our society that are here to protect us. I understand in even discussing this piece of legislation, some were concerned, are we doing something carte blanche to protect those that might be doing something willfully? But in this legislation, we are very clear. If the actions are done deliberately, they could be prosecuted or charged. If they do something on purpose, if they do something with willful intent, all we're attempting to do is something happens based on hurricane, something happens based on a breakdown of equipment or anything that could come about, you cannot hold people liable. So we're just trying to protect it from that aspect, but guaranteeing without taking away the rights of internally, whether through the office, whether through individuals that choose to sue or protect their rights if they feel that they were done something wrong. They have that right. I'm not taking that away through this legislation. We are attempting to protect those that are amongst us, that are attempting to protect and serve our society, but not making them liable when something is not done intentionally or even their fault. So again, I am looking forward to the conversation. I'm looking forward to the testimony. Even if you have suggestions as ways to improve this piece of legislation, I am always open, as I am a representative that always attempts to listen, because my legislation is here to better the lives of the people of this territory. So thank you, Mr. Chair, and I will wait for the relevant testimony and questions.
Thank you, Senator Heiliger. Francis Heiliger. We will start with the testifiers for bill number 36-0057. And introduce yourself before you begin to speak.
Good morning, Honorable Chair Clifford Joseph, legislative body and members of the VIPD, and the listening and viewing audience. My name is Sean Santos, and I am the Assistant Commissioner of the United States Virgin Islands Police Department.
Yeah.
I come before you on behalf of Police Commissioner Mario Brooks to provide testimony on bill number 36-0057, an act amending Title 5 of the Virgin Islands Code, Chapter 314, Section 3733, subsection A, to require automatic expungement of the arrest record and complaint or information when the accused has been acquitted, sponsored by Senator Alma Francis Heiliger. We offer our support for bill number 36-0057, which proposes to amend Title 5 of the Virgin Islands Code, Chapter 314, Section 3733A, to require the automatic expungement of the arrest record and complaint or information when an individual is acquitted of criminal charges. This bill reflects a long overdue step toward ensuring fairness and justice in the justice system by protecting the reputational, social, and economic interests of individuals who have been found not guilty by a court of law. However, we recommend that this bill include specific safeguards and stipulations, especially in cases involving prior arrests of felonious violations, to maintain public safety and balance the right to privacy with interests of law enforcement and the community. The foundation of the criminal justice system is the perception of innocence until proven guilty. When a person is acquitted, the legal system has determined that the government failed to meet its burden of proof. Yet, individuals with dismissed charges or acquittals often continue to face collateral consequences, including employment discrimination, housing denial, or social stigma simply because of the lingering presence of an arrest record. Automatic expungement affirms the principle that a person should not be punished for a crime they did not commit, and supports restorative justice by allowing them to move forward without unnecessary barriers. A growing number of U.S. jurisdictions, including Pennsylvania, Utah, and California, have enacted clean slate or an automatic expungement laws to ensure people who are acquitted or have charges dismissed are not burdened by arrest records. According to the 2020 report by the Brennan Center of Justice, such reforms have no measurable negative impact on public safety and, in fact, contribute to greater community reintegration and reduce recidivism. Automatic expungement reduces the blockage of inefficiencies in the court of law and enforcement systems by eliminating the need for formal petitions, hearings, and attorney involvement in uncontested case of acquittal. To ensure that the public safety remains paramount, I respectfully propose that the following stipulations be included or clarified in final version of the bill. Individuals with prior arrests or convictions for felonious offenses within a denied look-back period, for example, 5 to 10 years, should not be eligible for automatic expungement, even if they acquitted of the current charge, unless a separate petition is filed and approved by the court. This ensures that patterns of behavior or serious prior conduct are considered before records are sealed. Expunged records should remain accessible to law enforcement agencies, the Attorney General's office, and the judiciary for investigative or sentencing purposes, even if no longer publicly visible. This strikes a balance between individual privacy and the operational needs for criminal justice entities. The bill should specify that automatic expungement applies only to non-violent offenses, and that the acquittals for offenses involving weapons, sexual violence, or other crimes against persons should be subject to the judicial review before expungement is granted. In conclusion, Bill number 36-0057 is a vital step towards equity and justice for individuals who have been acquitted and deserve the opportunity to clear their names with the inclusion of reasonable safeguards, particularly concerning prior felony histories and violent offense exclusions. This legislation can promote both fairness and public safety. I commend Senator Alma Francis Heiliger for her leadership on this matter and respectfully urge the legislature to pass this bill with necessary amendments to ensure balance and effective implementation. I want to thank each and everyone for you listening to it as I speak of this testimony, and I now stand by for any questions you may have. Thank you.
Thank you. The next testify on 0057, 360057.
Good afternoon. My name is Julie Smith Todman, and I am the Chief Territorial Public Defender for the Office of the Territorial Public Defender, which we call the OTPD. Let me begin by thanking the Chairman, the members and staff of the Committee on Homeland Security, Justice, and Public Safety of the 36th Legislature for this invitation to testify on proposed Bill number 36-0057, an act amending Title V, Virgin Islands Code, Chapter 314, Section 3733, subsection A, to require automatic expungement of the arrest record and complaint or information when the accused has been acquitted. Let me also extend my sincere gratitude to Senator Alma Francis Heiliger as the sponsor of the proposed bill. I would also like to extend warm greetings to each of you in the listening and viewing audience, distinguished guests, and to the members and staff of the 36th Legislature. The Office of the Territorial Public Defender was established by Title V, Section 3521 of the Virgin Islands Code to represent the indigent charged with crimes in court. I appreciate the opportunity to provide you with the position of my office as to the changes to 5 Virgin Islands Code 3733 subsection A. After considering the amendments promulgated in Bill 36-0057, Bill 57, the Office of the Territorial Public Defender fully supports the contemplated changes. OTPD generally supports any effort to increase the availability and efficacy of expungements under territorial law. Bill 57 will amend Title V, Virgin Islands Code, Chapter 314, Section 33 to mandate automatic expungement of arrest and charging records upon acquittal. This transformative bill aligns the Virgin Islands with 9 U.S. states and the nationwide Clean Slate movement, emphasizing significant cost savings and ensuring justice for Virgin Islanders. To quote Justice Sotomayor, "Even if you are innocent, you will now join the 65 million Americans with an arrest record and experience the civil death of discrimination by employers, landlords, and whoever else conducts a background check." In the Virgin Islands, where most arrests are warrantless, acquitted individuals face a civil death of discrimination. This is because arrest records, even after acquittal, can block jobs, housing, education, licenses, and volunteer roles, and these records are generally available for access by employers, landlords, and whoever else conducts a background check. The OTPD previously testified before this body in the 35th Legislature for the expansion of automatic expungements in cases where no probable cause was found by a judge. That bill was passed and is now codified as Title V, Virgin Islands Code 3732A. In my prior testimony, and what is still relevant today, I noted that in the past, there was a prevailing attitude that it was unnecessary to regulate access to outcomes less serious than a conviction, partially based upon the practical obscurity of most criminal records. However, the advent of digitized record systems has opened up an entirely new industry that traffics in personal information. A criminal record, even when it is only the record of an arrest with no conviction, can have serious impacts upon a person's life. Here are some examples of that impact. Schools can and have denied admission to students based upon criminal arrests. Employers and licensing authorities can and have denied employment and professional licenses based upon criminal arrests. Landlords can and have denied housing based upon criminal arrests. Insurance companies can and have utilized arrest records as the basis for higher premiums. Other countries can and have denied entry to visitors with an arrest record. Well-intentioned community groups can and have utilized arrest records to deny access to volunteer opportunities. Bill 57 will lower the harm done to the innocent by automatically expunging the arrest and charging records for those acquitted of the charges. While untold moral benefits remain, there are also economic benefits that should be considered. For example, expungement raises wages by 23%, cutting local welfare costs. Furthermore, Bill 57 would result in reduction in recidivism rates, as demonstrated in Michigan, where only 4% of Michigan expungement recipients are reconvicted within 5 years, mostly for minor offenses. Bill 57 delivers crucial benefits. Automatic expungement removes barriers to employment, housing, and education caused by arrest records, even for those acquitted. Expungement can raise wages by 23% and add tax revenue. According to the empirical study by J.J. Prescott and Sonia B. Starr, only 4.2% of individuals who received expungements were reconvicted within 5 years. The petition-based expungement process under VI Code Title V, Section 3733, subsection A, subsection 2, strains courts and individuals. Automatic expungement reduces backlogs and costs. In the Virgin Islands, this efficiency will free judicial resources for active cases, ensuring swift relief for the acquitted. An acquittal affirms innocence, yet persistent records stigmatize individuals, limiting civic participation. Bill 57 restores dignity by clearing records, aligning with the principle that justice does not penalize the innocent. This builds public trust, reinforcing faith in Virgin Islands' justice system. By allowing for the automatic expungement of these records upon acquittal, the Virgin Islands joins a growing movement. The Office of the Territorial Public Defender fully supports efforts to increase the availability of expungements for Virgin Islanders. Making these processes automatic provides a great benefit to our citizens. I am pleased to provide my office's wholehearted support behind Bill 36-0057 as a crucial step toward a more equitable justice system. I thank you for the opportunity to address this issue.
Thank you. The next testifier on 0057.
Yes, Gordon Ray, Attorney General, Department of Justice. Good afternoon, Chairman Clifford Joseph Sr., Committee on Homeland Security, Justice, and Public Safety members, senators, legislative staff, and the listening and viewing audience. I'm Attorney General Gordon Ray. It's an honor and privilege to appear before you this afternoon. The Department of Justice appreciates the opportunity to comment on Bill number 36-0057. We've completed a preliminary review of the bill and offer the following comments. Bill 36-0057 seeks to amend Title V of the Virgin Islands Code, Chapter 314, Sections 3733, Subsection A, to require the automatic expungement of the arrest record and complaint or information when the accused has been acquitted. It's estimated that 77 million Americans, or 1 in 3 adults, have some type of criminal record. Having a criminal record, including an arrest record or criminal charges, can affect a person's ability to obtain employment, higher education, and housing. These obstacles can lead to increased poverty, racial disparities, crime, and recidivism. While there is real interest in decreasing these barriers, we must remember there is also a public interest in criminal justice, which remains a key government function. An acquittal occurs when there's a finding by a court or jury that a defendant, or someone who's been accused in a court of law, is not guilty of a crime. Quote, in common law jurisdictions, an acquittal means that the criminal prosecution has failed to prove that the accused is guilty beyond a reasonable doubt of the charge presented, end quote. And that's from a case. It does not, however, mean that the individual accused is not responsible for the crime they were accused of. Bill number 36-0057 proposes to require the automatic expungement of the arrest record and complaint or information when someone has been acquitted. The bill states, quote, upon the acquittal of an accused, the court shall enter an order expunging the accused record of the arrest and the criminal complaint or information upon which the accused was tried. Expungement is defined by the Virgin Islands Code as, quote, the sealing of criminal records within any court, correctional facility, police department, or other law enforcement agency concerning a person's arrest, detention, apprehension, trial, or disposition of an offense within the criminal justice system, end quote. Further, records include all arrest records, complaints, warrants, summons, commitments, processing records, photographs, judicial docket records, fingerprints, and the collection of DNA samples. Bill number 36-0057 weakens the laws related to the expungement of criminal records and due process protections that already exist within the territory. Virgin Islands law currently requires the expungement of the arrest records, criminal complaint, or of any information that does not result in a conviction when, upon petition to the court, 1, where the case has been dismissed without prejudice and the statute of limitations has expired; 2, where the case has been tried and there was an acquittal; 3, where there is a statement of null prosecute and the people have not filed an information or complaint and the statute of limitations has expired. Additionally, Virgin Islands law allows for the expungement of criminal records that do not result in prosecution, including when a person successfully completes the pretrial intervention program, when a person has received a statement of null pros, when a person's case has been dismissed with prejudice, or a person has been arrested and no complaint or information has been filed and the statute of limitations has expired. Expungements are also allowed for misdemeanor convictions and certain marijuana-related convictions. The proposed legislation goes a step further by requiring the automatic expungement of the arrest record and criminal complaint or information of a person accused of a crime and acquitted. The territory's existing expungement laws already provide a right to expungement, including mandatory expungement in many cases. They also provide due process, ensuring fairness to both residents and the government. Beyond legal and practical considerations, there are also collateral consequences of expunging the record of arrest and the criminal complaint or information of an accused. These include the destruction of DNA samples and the erasure of their prior history or contact with law enforcement. A person's prior contact with law enforcement and their history of charges are important pieces of information for prosecutors when evaluating how best to proceed with the case. For example, the proposed law calls for the expungement or permanent destruction of the record of an arrest, which includes fingerprints and DNA samples. Currently, pursuant to Virgin Islands Code, a DNA sample is collected from a suspect upon their arrest of a misdemeanor or felony sex offense. That DNA sample is then uploaded to CODIS, or the Combined DNA Index System, which is maintained by the FBI. Within the CODIS system, hits occur when DNA from a crime scene is matched to another DNA profile in the database. This is a valuable tool used by law enforcement to identify suspects in murder, rape, and unsolved cold cases. The proposed legislation could prevent a suspect's DNA from being entered into or remaining in CODIS, eliminating a useful resource for the Virgin Islands. Further, when a suspect is arrested, information related to the arrest is added to the National Crime Information Center, or NCIC, database. The proposed law would automatically remove this entry. The NCIC is routinely used by law enforcement officers and personnel and is directly related to officer safety. For instance, when an officer initiates a traffic stop or prepares to arrest a suspect, the officer can check the NCIC for past arrests, including arrests involving guns or violence, to determine if there is a safety concern. Similarly, a person's prior contact with law enforcement and their history of charges, as recorded in the NCIC, are important pieces of information for prosecutors when evaluating how best to proceed with a case. The Department of Justice's preference is to maintain the opportunity for its attorneys and an impartial judge to evaluate a petition for expungement for legal sufficiency and appropriateness. Currently, sufficient expungement laws exist within the territory to facilitate due process and other concerns that should be considered. It would be beneficial to use our resources to make existing expungement laws more accessible to residents who would otherwise qualify. I thank the committee for allowing the Department of Justice to testify on this bill. This concludes my formal remarks, and I respectfully welcome any questions this body may have.
Thank you, Attorney General Ray. We will next have the testifiers for Bill number 360024. Please state your name and title and place your testimony on the record.
Good afternoon. My name is Deborah Hodge, and I am the Acting Chief of Police in Thomas and John, White Island District. Good afternoon again, Honorable Mr. Chairman Clifford Joseph Sr., members of the Committee on Homeland Security, Justice, and Public Safety, all other distinguished members of the Senate, and listening and viewing audience. As mentioned, I am Deborah Hodge, Acting Chief of Police for the St. Thomas St. John Water Island District. On behalf of Police Commissioner Maria Brooks, I submit this testimony in support of Bill number 36-0024, which seeks to amend Title 14 of the Virgin Islands Code, Chapter 85, by adding Section 1710 to declare that a person in police custody is incapable of consenting to sexual relations. Herein, I will request that the term police officer be replaced with law enforcement officer to reflect the importance of this legislation to cover all sworn personnel within this jurisdiction. This legislative amendment is not only necessary for closing a critical legal gap, but also aligns the Virgin Islands with existing federal law and best practices adopted by a majority of U.S. states. Please note that while VIPD officers have associated policies as well as issued body cams that are mandated to be in record mode when chasing, apprehending, and transporting persons of interest, suspects, or any other persons within the community aligned with criminal activity. Not all law enforcement personnel who serve within the territory have the same policies. The United States Congress has already recognized the inherent coercion in custodial settings by enacting 18 United States Code subsection 2243C, which makes it a federal crime punishable up to 15 years in prison for any federal law enforcement officer to knowingly engage in a sexual act with an individual who is under arrest, under supervision, in detention, or in federal custody. Notably, under this law, consent is not a valid defense. This federal statute reflects the understanding that individuals in custody cannot freely consent due to the power imbalance between them and law enforcement officers. However, because of 18 U.S. Code subsection 2243C applies only to federal law enforcement officers, state and territorial agencies must enact their own laws to ensure that all officers, whether local, territorial, or municipal, are held to the same standard. By passing Bill number 36-0024, the Virgin Islands Legislature will ensure that territorial law enforcement officers are subject to the same strict accountability as their federal counterparts. Cases of sexual misconduct, while not representative of the majority of law enforcement personnel who serve honorably, undermine public trust when they occur. Data from the Bureau of Justice Statistics and investigative reports from the U.S. Department of Justice reveal troubling patterns. A 2016 Bureau of Justice report found that more than half of substantiated cases of law enforcement sexual misconduct involve victims who were in custody or otherwise under law enforcement authority. A 2018 nationwide study found that at least 35 states have passed laws explicitly prohibiting law enforcement officers from engaging in sexual acts with individuals in custody, regardless of claimed consent. Despite these alarming statistics, some jurisdictions without clear statutes have seen officers successfully argue that their encounters were consensual. This legal loophole must be closed to ensure that no person in custody is ever placed in a position of coercion or exploitation. Trust between law enforcement and the community is the foundation of effective policing. When instances of sexual misconduct occur, they not only harm the victims, but also tarnish the reputation of all law enforcement officers and erode public confidence in law enforcement agencies. By passing Bill number 36-0024, the Virgin Islands will align itself with federal law 18 United States Code subsection 2243C and ensure local law enforcement officers are held to the same standards as federal officers. Eliminate any ambiguity in the law by stating that individuals in custody cannot consent to sexual relations with law enforcement officers. And protect the integrity of the Virgin Islands Police Department and our local law enforcement colleagues by reinforcing our commitment to ethical policing and public trust. We urge the committee to fully support and advance Bill number 36-0024. This legislation is not about restricting the rights of officers. It is about ensuring that the power entrusted to law enforcement is never used to exploit vulnerable individuals. It upholds the principles of justice, accountability, and public trust, all of which are essential to maintaining a fair and effective criminal justice system in the Virgin Islands. Thank you for your time and consideration. I will remain on standby to welcome any questions from the committee.
Thank you. Gordon Ray.
Good afternoon.
Good afternoon.
Chairman Clifford Joseph Sr., the Committee on Homeland Security, Justice, and Public Safety members, senators, legislative staff, and the listening and viewing audiences. I am Attorney General Gordon Ray, and it's an honor and a privilege to appear before you again. The Department of Justice appreciates this opportunity to comment on Bill number 36-0024. We've completed a preliminary review of the bill and offer the following comments. Bill 36-0024 seeks to amend Title 14 of the Virgin Islands Code, Chapter 85, by adding a new Section 1710. If enacted, this proposed new section would make a person incapable of consenting to sexual relations while they are in police custody. Police officers are entrusted with the power to enforce laws and have the authority to detain, search, and arrest people while doing so. Unfortunately, this power can also be used to restrict the freedoms of and violate the rights of citizens. Because of the inherent power imbalance between law enforcement officers and the civilians they come into contact with during the course of their work, many jurisdictions recognize any sexual interaction between the two as inherently coercive and non-consensual. Others do not. In 2022, Title 18 of the U.S. Code, Section 2243, was amended to add a new subsection C, making it illegal for anyone acting in the capacity as a federal law enforcement officer to knowingly engage in a sexual act with an individual who is under arrest, under supervision, in detention, or in federal custody. This section also establishes the possible penalties for violation of the statute, which include a fine, imprisonment up to 15 years, or both. It should be noted, however, that the penalties for violation of 18 U.S. Code Section 2244A6 in violation of 18 U.S. Code 2243C are a fine, imprisonment up to 2 years, or both. Consent is not a defense to a violation of either of these federal statutes. Additionally, many states have enacted laws making sexual conduct by police officers a crime. Because states and territories have the autonomy to govern themselves, the scope and application of these laws vary greatly. Some jurisdictions prohibit sexual contact between a law enforcement officer and someone they have encountered during any and all stages of police interaction. Others only prohibit sexual contact while a person is in custody. Yet, other states do not have any laws expressly prohibiting or criminalizing sexual contact between a police officer and someone they come in contact with while performing their law enforcement duties. The strongest laws provide protection against sexual conduct from police officers during any interaction while the officer is in the line of duty and are not limited to when a person is in custody. They also address consent and prevent an officer from using consent as a defense to a claim for sexual misconduct. For example, in Vermont, a law enforcement officer may not engage in a sexual act or sexual conduct, as defined by state statute, with a person whom the officer is detaining, arresting, or otherwise holding in custody, or who the officer knows is being detained, arrested, or otherwise held in custody by another law enforcement officer, including during traffic stops and questioning pursuant to an investigation of a crime. A violation of Vermont's law can result in imprisonment up to 5 years, a fine not more than $10,000 or both. Similarly, in Colorado, a police officer commits unlawful sexual conduct by knowingly engaging in sexual contact, sexual intrusion, or sexual penetration when the officer contacts the victim for purposes of law enforcement, or the peace officer knows the victim is, or causes the victim to believe they are, the subject of an active investigation and uses that knowledge to further the sexual contact, or the officer makes any showing of real or apparent authority in furtherance of sexual contact. Colorado classifies unlawful sexual conduct by a police officer as a Class 4 or 3 felony. Depending on the severity of the conduct, Colorado law also prevents consent from being a defense to unlawful sexual conduct by a peace officer. In contrast, in Alaska, it is sexual assault in the third degree, a Class C felony, for a police officer to engage in sexual penetration with a person with reckless disregard that the person is in the custody or the apparent custody of the offender, or is committed to the custody of a law enforcement agency while employed in the state by a law enforcement agency. However, custody is not defined by the statute and is therefore open to interpretation. Any ambiguity in the statute could be used in an attempt to create a legal excuse or justification for the alleged crime. Laws regarding sexual conduct and violence by police officers during the course of their official duties vary by state, resulting in different levels of protection for victims. The strongest statutes explicitly apply to all forms of law enforcement activity during any point in the line of duty, including the initial encounter, and should clearly state that any sexual contact between an officer and an individual encountered in the line of duty is, by definition, non-consensual. The proposed statute does both. The Department of Justice supports Bill number 36-0024 in principle. With that said, the following should be considered as you review the bill. First, Bill number 36-0024 does not create a crime that can be violated. Rather, it focuses on consent. Specifically, the bill centers on when a person is incapable of consenting to sexual relations and does not include any penalties. Instead, an officer in violation of the proposed new section, 1710, would be subject to the penalties for rape and related offenses codified in Title 14, Chapter 85 of the VI Code. Secondly, Bill number 36-0024 does not include any reporting requirements. By establishing a system that requires mandatory reporting of police sexual violence, the VI Police Department and other agencies that employ peace officers can track complaints made against officers and investigate allegations to determine whether there is a recurring or widespread problem. I thank the committee for allowing the DOJ to testify on Bill number 36-0024. This concludes my formal remarks, and I welcome any questions. Thank you.
Thank you. I'll have the next testifier, Ms. Julie Smith Thomas. Todman.
Thank you. Good afternoon, Senator Joseph Sr. My name is Julie Smith Todman, and I am the Chief Territorial Public Defender for the Office of the Territorial Public Defender, which we call the OTPD. Let me begin by thanking the Chairman of the Committee on Homeland Security, Justice, and Public Safety, Senator Clifford A. Joseph Sr., for the invitation to testify on this matter. I also extend my gratitude to each of you in the listening and viewing audience, distinguished guests, and to the members and staff of the 36th Legislature, and to the bill sponsor, Senator Ray Fonseca. The Office of the Territorial Public Defender was established by Title V, Section 3521 of the Virgin Islands Code to represent the indigent charged with crimes in court. I was invited to provide my testimony concerning Bill number 36-0024, which is an act amending Title 14, Virgin Islands Code, Chapter 85, by adding Section 1710, declaring a person incapable of consent to sexual relations while the person is in police custody. Bill number 36-0024, or Bill 24, was proposed by the Honorable Senator Ray Fonseca. Section 1710 provides that Section A person is incapable of consent to sexual relations when the person is detained, under arrest, or is otherwise in the custody of a police officer or other law enforcement official, and the offender is a police officer or other law enforcement official who either, 1, detained or arrested the person or is responsible for the person's custody, or 2, knows or should reasonably know that the person is under arrest or in custody. The term sexual relations means sexual contact, sexual intercourse, or sodomy as defined in Section 1699 of this chapter. OTPD takes a neutral position on the overall goal of the legislation and limits its input to point out some possible ambiguities with the usage of the custody in the bill. Taking up just a few lines, the proposed legislation is obviously very simple in word and in scope. One complicating notion is what it means to be in the custody of police or law enforcement. Because some special rights attach to persons in custody, the phrase does get regular attention by the courts. For the same reasons, however, the phrase's usage may be complicated. Because Bill 24 addresses the issue of consent in situations where a person is in police custody, Bill 24 focuses on important new distinctions that are more nuanced than those of inmate and would eliminate the ability of a person to consent to sexual relations when that person is detained, under arrest, or is otherwise in the custody of a police officer or other law enforcement official who either placed the person in custody, is responsible for the custody, or reasonably knows that the person is under arrest or in custody. What does it mean to be detained or in custody? And how does Bill 24 change current rights? Bill 24 clarifies when a person loses the ability to consent to sex and broadens the circumstances under which consent is not legally recognized, including when someone is detained or in custody. In the United States Virgin Islands, the concept of being in custody, custodial interrogation, or being detained by the police stems and flows from a case involving whether certain Miranda warnings were given before police questioning, whether Miranda warnings are required or not was addressed in a case known as Miranda versus Arizona. For example, this discussion by the Supreme Court of the Virgin Islands setting forth the factors to be determined to define whether an individual is in custody. A suspect is deemed to be in custody for Miranda purposes when the suspect has been deprived of freedom of action in any significant way. An inquiry regarding whether a person was held in custody often hinges on the totality of the circumstances. Holding that the custody for Miranda purposes is determined by examining the totality of the circumstances surrounding interrogation and determining whether a reasonable person would have felt free to terminate the interrogation and leave. The United States Court of Appeals for the Third Circuit has enunciated 5 factors which we will also apply to this case to assess whether the defendant was held in custody. United States versus King. These factors include 1, whether an officer advised the defendant that he was under arrest or that the defendant was free to leave, the location or physical surroundings of the interrogation, the duration of the interrogation, whether the officer used coercive tactics, included hostile tones in the officer's voice, display of a weapon, or conduct where the officer physically restrains the defendant's movements, and 5, whether the defendant voluntarily submitted to the questioning from the officer. The 5-part custody test applied by the Third Circuit in King and quoted by our own Supreme Court above is just one custodial test. Not to be outdone, the 8th Circuit U.S. Circuit Court of Appeals has their own 6-part test. The important takeaway is that custody can mean more than one thing. The central inquiry is whether, under the totality of the circumstances, a reasonable person in the suspect's position would feel not free to leave to a degree associated with a formal arrest. This standard, often referred to as the reasonable person standard, is fact-specific and considers factors such as the location, duration, and nature of the questioning, as well as the presence of coercive tactics or physical restraints. The nature of this legislation raises other concerns. Would it apply in the case of the defendant in his home, but under curfew by the court or electronic monitoring? I have provided several scenarios. We don't know what standards Bill 24 proposes to apply. Does it propose a similar standards to those that are used in Miranda to determine when a person is in custody and therefore cannot consent to sexual relations? Bill 24, in its brevity, appears aimed to protect individuals under the control of the government and clarifies that certain sexual activity between those in custody and the law enforcement officials is non-consensual and is thus punishable under criminal law. There is nothing that compels the legislature to apply the same definition of custody, detention, or under arrest as utilized by the courts when resolving issues relating to custodial statements. However, there is some danger that without a discrete definition for those terms, the application of current standards would result in undesirable effects. I thank the committee for your invitation. Thank you.
Thank you. Colleagues, we will have a 6-minute round. Oh, sorry. Lastly, we will have testimony on Bill 360031. State your name, title, and place your testimony on the record. Gordon Ray.
Good afternoon.
Okay. Just go ahead. Vaitima, go ahead. Mr. Williams.
Okay. Hi, good afternoon.
Good afternoon, we could hear you.
Ovid Williams, Assistant Director of Vaitima.
You could proceed with your testimony. Proceed with your testimony.
Thank you. Good afternoon, Senator Clifford A. Joseph Sr., Chairman of the Committee on Homeland Security, Justice, and Public Safety, other committee members, the 36 legislature staff, and those in the viewing and listening audience. I am Ovid J. Williams, Assistant Director of the Virgin Islands Territorial Emergency Management Agency, which has the responsibility for the territory's 911 Emergency Communication Center, also known as the Public Safety Answering Points. With me today are Vaitima's Deputy Director of Operations, Mr. Bruce Kelly, and Deputy Director of Logistics, Mr. Asim Fred. We are providing testimony to Bill number 36-0031, sponsored by the Honorable Senator Alma Francis Heiliger, an act amending Title 23 Virgin Islands Code, Chapter 10, Subchapter 4, Sections 1073, to exempt a public safety agency or private safety entity from liability for acts of negligence in the operation, administration, or maintenance of a 911 service unless the acts are committed in a grossly negligent manner or are committed with willful intent. Let me start my testimony with a review of the existing key definitions which impact this bill. The first definition comes from VI Code Section 1071-911. Definitions for 911 service, which means the telecommunications service which provides the user of the public telephone system the ability to reach a public safety answering point by dialing the digits 911. The second is public safety agency, which means a functional division of a public agency which provides ambulance, firefighting, law enforcement, medical, or other emergency services. And the third, private safety entity, means a private entity which provides ambulance, firefighting, law enforcement, medical, or other emergency services. Vaitima operates 2 public safety answering points, or PSAPs, for 911 calls or text messages. One PSAP is located on St. Croix, serving approximately 40,000 residents, businesses, and visitors, and one on St. Thomas, serving the approximately 48,000 residents, businesses, and visitors to St. Thomas, St. John, and Water Island. During times of high volume requests for 911 service, each PSAP can answer requests for the other, but can only dispatch first responders via government radio trunking system to fire, police, emergency medical services, or rescue from the originating call from the PSAP district. By design, in the U.S. Virgin Islands, a 911 service call or text does not go directly to fire, police, emergency medical services, or rescue, but rather it is routed through one or multiple telecommunication carriers, ultimately to the Vaitima PSAP. In instances of mobile phones, a call is routed first to the cell tower with the strongest signal, regardless of the individual's paid service provider. Mobile phones, calls to 911 over the internet or Wi-Fi are not guaranteed to reach Vitima's PSAPs, as the request is routed through the phone's registered address, which may or may not be in the U.S. Virgin Islands. Text messages to Vitima PSAPs is successful only through mobile cell phone providers and not over the internet. Private telecommunications providers operate, maintain, and administer all aspects of connecting a 911 service call from a phone, landline, or mobile to the Vitima's PSAPs. In rare instances where the call path fails due to hardware or software recognition at the PSAP, a call can be answered at an alternate center. If the outage is expected to last more than 60 minutes, Vitima initiates a switch to a secondary line to install at both 911 centers until the issue is resolved. An important note is that Vitima is not notified by telecom providers when service is impacted outside that of equipment connected to Vitima's PSAPs, such as a cell tower or other service interruptions. Pursuant to FCC Order Number 24-73, relative to 911 outages, notifications to PSAP and to PSAPs, such as the Virgin Islands Territory Emergency Management Agency, effective April 15, 2025, originating service providers, such as Liberty Mobile USVI, must notify Vitima as soon as possible, but no later than 30 minutes of an outage. In addition, OSP or the originating service providers must follow up in 2-hour intervals of the original notification to provide additional material information through the time of the resolution. The FCC orders requires OSPs to create and maintain an accurate, up-to-date contact list for the purposes of notifying PSPs of service outages. In a few instances, when there have been longer 911 service outages, Vitima generates a mass message notice for the impacted district using its Alert VI to subscribers, powered by Everbridge, which provides event-critical management services, informing of the service outage and providing local police, fire, emergency medical services numbers to call directly for assistance. During this downtime, any calls or texts using 911 would not be received or answered by the PSAP. Once 911 service has been restored, another Alert VI message is sent by Vitima informing that 911 has been restored. An important impact of calling the local numbers during the time of the outage is that, unlike calling 911 PSAP, none of the calls are recorded. When contacting Vitima 911 PSAP, all calls and texts are recorded on the computer-aided dispatch record management system. The obvious impact of losing 911 service is that public safety agencies and private safety agencies are not aware of the emergency, and once they become aware, are delayed in their response time. As Bill number 360031 proposes, during these 911 service outages, all emergency services are unaware or at their best delayed in life-saving efforts. And as a result, any public safety agency or private safety entities should be exempt from liability for acts of negligence in the operation, administration, or maintenance of any 911 service call unless the acts are committed in a grossly negligent manner or are committed with willful intent. Vitima fully supports Bill number 36-0031. Thank you, Senator Clifford A. Joseph Sr., Committee Chairman, for the opportunity to provide testimony to this bill. We are prepared to answer any questions the members of your committee may have at this time.
Thank you. Attorney General.
Good afternoon, Chairman Clifford Joseph Sr., Committee on Homeland Security, Justice, and Public Safety members, senators, legislative staff, and the listening and viewing audiences. I'm Attorney General Gordon Ray. It's an honor and privilege to appear before you again this afternoon. The Department of Justice appreciates the opportunity to comment on Bill number 36-0031. We've completed a preliminary review of the bill and offer the following comments. Bill 0031, seeks to amend Title 23 of the Virgin Islands Code, Chapter 10, Subchapter 4, Section 1073, by inserting a new subsection C to exempt a public safety agency or private safety entity from liability for acts of negligence in the operation, administration, or maintenance of a 9/11 service, unless the acts are committed in a grossly negligent manner or are committed with willful intent. Liability for agencies providing 9/11 services is a valid concern, as liability can result in costly legal and financial obligations. These service providers may face liability for negligence, especially when their actions lead to harm. Although there are laws that often protect local and state governments and their actors against tort liability, this protection is not afforded in every jurisdiction and does not always extend to third-party service providers. For example, in the Virgin Islands, the government waives its immunity from liability and assumes liability with respect to injury, loss of property, or death caused by the negligent or wrongful act or omission of an employee while acting within the scope of their office or employment. This waiver of immunity from liability does not apply, however, if the injury or loss of property is caused by the gross negligence of an employee of the government of the Virgin Islands while acting within the scope of their office or employment. Gross negligence is a higher level of negligence than ordinary negligence, involving a severe lack of care and often demonstrates a conscious and reckless disregard for safety. Several states limit liability for 9/11 operators, protecting them from lawsuits for damages related to system failures or errors, unless the injury was caused by wrongful acts or gross negligence. These limits are intended to encourage the development and maintenance of emergency communication systems without the threat of excessive and expensive lawsuits. In South Dakota, in contracting for the 9/11 emergency reporting system or the provisioning of the 9/11 service, except for willful or wanton negligence or intentional acts, the board, the governing body, the public agency, the service provider, the prepaid wireless service provider, the prepaid wireless service seller, and the service supplier, their employees and agents are immune from liability for a failure in the use or operation of the 9/11 system. Kansas limits liability for each provider and their employees, agents, suppliers, and subcontractors, and each seller and their employees, agents, suppliers, and subcontractors shall not be liable for the payment of damages resulting directly or indirectly from the total or partial failure of any transmission to an emergency communication service, or for damages resulting from the performance of installing, maintaining, or providing 9/11 service. In North Carolina, the standard of proof or the level of certainty required to prove a claim in a legal proceeding for liability for public safety telecommunicators and dispatchers is established by statute. As a result, a plaintiff's burden of proof is by clear and convincing evidence in any civil action arising from any act or omission by the defendant in the performance of any lawful and prescribed actions pertaining to the defendant's assigned job duties as a 9/11 or public safety telecommunication or telecommunicator or dispatcher. Clear and convincing evidence requires a higher degree of certainty than the preponderance of the evidence standard, which is often used in civil cases. The decision to exempt a public safety agency or private safety entity from liability for acts of negligence in the operation, administration, or maintenance of a 9/11 service is a policy decision, not a legal one. While liability can be limited through statutory immunity, a clear standard of conduct should still be expected. And I could add that I myself favor the proposal. I thank the committee for allowing DOJ to testify on Bill number 36-0057. This concludes my formal remarks, and I respectfully welcome any questions this body may have.
Thank you. Colleagues, we will be having a 5-minute round for these three measures. Starting off with Senator Angel Boquez. You're recognized for your 5 minutes.
Thank you, Mr. Chair. Good afternoon, Mr. Chair. Good afternoon, colleagues, and good afternoon once again for this last block to the listening and viewing audience. Starting off with bill number 36-0057, the automatic expungement. I want to say this is I believe is a good bill. It seems as if there is a few tweaks that may need to happen. However, I do have a question for the Attorney General. In your testimony, you mentioned that existing Virgin Islands law already allows for expungement in cases of acquittal through a petition.
Yes.
And why, if I might ask, why does the Department of Justice believe automatic expungement threatens due process protections if those individuals were already found not guilty?
Right. Well, every case is different. And if a petition is filed, then a court has to take a look at the underlying facts. And there may be some very important underlying facts in a case, even when someone's acquitted. For instance, what if they had a couple of prior arrests for that same sort of behavior, but that evidence was not presented to a jury for various evidentiary legal reasons? And that would raise the risk. That would be something I think a judge should know about, because if the judge does expunge the record, then in the future, if the person got in the same kinds of issues, the police and law enforcement would not have the benefit of knowing that, okay, they've done this multiple times before. So there will be, that's the good thing about having a judge look at all the factors. Obviously, in an acquittal, I believe the probability would be an expungement, but there's going to be circumstances where it may not make any sense. And that's why it's good to have the judge look at all the factors and then be able to make a final decision. If it's automatic,
okay, so
there's no judgment being being rendered by a judge, and doesn't matter what the other factors are, it's gone.
So what you're saying, for clarity, is you or the Department of Justice's position would be more so of if auto expungement did pass, or if another version of it, you're saying that preference-wise, you would want the judge to rule that this matter be auto expunged based on the merits of the case. Is that what I'm hearing, if I can clarify?
Yes, and based on any other information that the prosecutor may need to bring before the judge with respect to this person, which would be...
Okay, understood. And I know the prime sponsor is listening as well. For 36-0024, declaring persons in custody incapable of consent, in your testimony, again, Attorney General, you support the bill in principle, but highlighted that it does not establish a criminal offense. Would you recommend that Section 1710 include explicit penalties? And if so, under which existing statute would you put such violations to be prosecuted?
Okay. To me, it has the feeling of being a separate crime, which is basically committing a sexual offense when someone's in your custody or under your domination or your control. And so I think it would be interesting to consider the drafting of a proposed criminal offense relating to this kind of conduct. Right now, this way the statute is set up, all it does is it doesn't create an offense. All it says is that the consent defense cannot be used by the accused.
Okay, very well, very well. And you did mention also Federal Statute 18 U.S.C. 2243.
Yes.
Which prohibits consent as a defense in similar circumstances.
Yes.
I'm assuming you're recommending that we point to that section, correct?
Yes, I think that would make sense.
Okay, very well, very well. And before my time expires, I'm going to go to 36-0031, limiting liability to 9. Mr. Chair, if I may please wrap up.
Yes, go ahead and wrap up.
Thank you very much, Mr. Chair. To Mr. Williams, you mentioned the FCC order number 24-73 appears to play a significant role in shaping how outages must be reported. How exactly would this new regulation intersect with the provisions proposed in this bill?
Good afternoon, Honorable Senator. I'll turn this over to my team for that answer. I'll hand it over to Didi Siemfried.
Good afternoon, Senate Committee. Senator, can you repeat the question, please?
There was a mention in the testimony provided, FCC order number 24-73, and it appears to be a significant role in shaping how outages must be reported, that FCC order number. So I'm trying to figure out how is that federal regulation going to intersect with the provisions of this bill? Is there any issue?
No issues, Senator, but as a carrier that provides 911 service to the community, those carriers are required to notify a PSAP of any outages on their network. So it doesn't, in fact, impact the service of the 911 center.
Okay. You may have to come up a little higher so that we can see your face, but I'll let the chair delegate that. So thank you for the time, Mr. Chair.
Thank you. Senator A.B. Lewis, you're recognized for your 5 minutes.
Thank you, Mr. Chair. Thank you. Good afternoon, colleagues. Good afternoon, testifiers. Good afternoon, people of the Virgin Islands. Some bills here, my son, in 10 minutes. But anyhow, Chief Hodge, good afternoon. Are there current internal policies within the VIPD that prohibit sexual contact between officers and detainees?
That is correct, sir.
If so, how are violations typically handled?
Well, I don't have the punitive measures, but we do have measures that address those behaviors.
All right, thank you.
Okay. It's in our matrix.
Okay. Do you, is there, I think in your testimony you alluded to some type of federal statute or something?
That is correct.
So this would be just like kind of adapting it and making a local, codifying it for local?
That is correct.
Locally?
Sir. Yes, sir.
All right. Attorney Ray.
Yes, sir.
Attorney General Ray. Would your office support companion legislation to ensure law enforcement officers found in violation of this law face decertification and disqualification from future service?
I guess whether that sort of a penalty should be imposed would again vary with the nature of the offense and exactly what the sexual contact was.
Hey, over here. Okay.
Right.
Ms. Tadman, given that the federal and other state jurisdictions have passed similar law, do you believe the Virgin Islands is overdue for this legal safeguard?
I believe that the law needs to be expanded. This legislation, I believe it's too limited, and we need to define, have definitions that will expand this law. I see that there is some amendments to be proposed, but I think it can go further.
All right. Chief Hodge, based on your knowledge, well, how long have you been with the VIPD?
29 years.
Good. One more year to go. Have there been, to your knowledge, have there been any complaints, investigations, or concern raised in recent years about inappropriate sexual conduct involving detainees and VIPD personnel?
To my knowledge, no. However, since you posed the question, I must add that
Come closer to the mic.
We have had allegations that were, after a thorough investigation, that were deemed false. So I think it would be in the best interest of all law enforcement officers that there's some sort of portion to it that references how we handle false complaints.
Thank you. AC Santos.
Yes, Senator.
Yeah. Your testimony proposes that expunged records remain available to law enforcement. Can you clarify how this access would be controlled and used, particularly in future investigations or sentencing decisions?
Good question, Senator. So the information that, well, first off, for the cases that are more violent, felonious, and so forth, by being able to continue obtaining that information may help in further, well, future cases in the event that this person has a history of that same nature of crime. So by being able to keep that information for future, in the event that something may come about, especially DNA evidence, that would assist our not only us in everyone in law enforcement, Senator.
Thank you. Attorney General, wouldn't maintaining public access to arrest records after an acquittal undermine the presumption of innocence enshrined in our justice system?
Time.
Well, I don't see that it undermines the presumption of innocence because, again, sometimes the fact of an arrest, even though nothing came from it, can be important in the law enforcement business, as was just said, because it gives you a record of sort of what that person has been involved with. And if these requests go by way of petition to a judge can weigh all of those various factors, the law enforcement interest, as well as the personal interest of the accused, how this might impact their life, et cetera, and come up with a fair decision that takes account of all of that. If it's just an automatic across the board, zoop, then injustice can happen.
Mr. Chairman, if I could follow up, please. I think these are three critical bills. Could I have a follow-up question here, please?
Yes, you go ahead.
I would like to ask this to the police chief, Ms. Hodge, and to the Attorney General. Could internal law enforcement databases like NCIC retain non-public arrest histories for officers' safety while still allowing public expungement for acquitted individuals?
I am not certain as to what the federal regulations are for NCIC as far as retaining if you have an expunged record. I'll have to check that.
All right, could you follow up on that and return that information
Absolutely,
to the chair, please?
Yes.
Attorney General, same question for you.
Yes, I'm not sure either. Obviously, the NCIC background record is critical. And my preference would have it available always to law enforcement. And perhaps there's some system, again, I just don't know a lot of the details on that, on the NCIC, but if it could be available to law enforcement, perhaps not, but perhaps not to the public, that could make a big difference.
Good. Mr. Chair, we're going to have another round? Well, let me dig in one more time here.
Go ahead, ask your question.
Sorry. Oh, man. Well, let me go to Mr. Williams. Assistant Director Williams.
Yes, sir.
Huh? You ready?
I'm here.
Good. is there any processes in place at Vitema to internally investigate near misses or failures in 911 service, even when they not rise to gross negligence?
At this time, so I'll hand this over to Deputy Director Bruce Kelly in regards to answering that specific question, sir.
Good afternoon, Senator. That's a very good question. Thanks for that. Can you hear me?
Yeah, loud and clear. Go ahead.
Okay, great. Currently, our internal processes with, of course, all calls are recorded, so we will pull the recordings, review those, and see if the operator acted outside of the scope of their services. And that's as far as the performance of the operator. If it's something that occurred that leads us to look at the technology within the center, then we will also do that and have our discussions with the carriers.
So, Mr. Kelly, before you go, in practical terms, whether it's you or Mr. Fred, in practical terms, how would you distinguish between ordinary negligence and gross negligence in the context of 911 services delays or errors?
Okay, so I would say ordinary negligence, and like we said, it depends on what it is. Gross negligence is something far outreaching, way overboard. Practical negligence would be something that could be somebody needed remedial training because of something they did versus something willful, which will be, I would determine as being gross.
That's a short answer, but I don't know if I'm comfortable with that one. But how often do your 911 operators receive training?
They receive initial training and then recertification trainings every 2 years. Initial training for roughly 1 year while they're on probation, and then initial and recertification trainings in certain disciplines every 2 years.
So throughout the full calendar year, no training is going on?
Not unless something specifically points to that or something arises within the 911 arena that we need to do a specific training.
I would say beg to differ and see a need for training throughout the year, some kind of refresher, some kind of update, keeping with the industry standards, the standards of what's going on in the 911 emergency world. But I would not abuse it anymore. Thank you, Mr. Chairman, for the flexibility. Thank you to the testifiers. Thank you for your responses.
Thank you, Senator Lewis. Senator Franklin Johnson, for your 5 minutes.
Good afternoon. Thank you very much. Good afternoon to the testifiers. Good afternoon to my colleagues, viewing and listening audience. I want to start off with bill number 360057, and my line of question goes to the Attorney General. You cite concern about destruction of records such as DNA samples and fingerprint. Can you clarify whether the current law permits the retention of such evidence even when a case is expunged?
Yeah, the present law, let me see, I can find it here for a second. It basically, shoot, I have several copies here, just 1 second. Okay. It has a provision that says, on no probable cause, the court shall simultaneously enter an order expunging the arrest record, including fingerprints, mugshots, DNA, and any other police or judicial proceeding records of a person. It doesn't say that specifically with respect to the expungement following an acquittal. And I think that's why it would be important for a judge to be able to look at the entire package and make a decision. Okay, well, the arrest record can disappear, some other things could disappear, but the DNA, because of the background, because of what happened, ought to stay in the DNA filing system so that if this person, if their DNA shows up again, we'll have the police and law enforcement will have a record.
As you say that current laws right now gives that judge that say to expunge or not. Am I correct to say that?
Yes, I think you're correct. And exactly what the expungement adds up to. What are all the elements in there? The judges do have some discretion.
You also, in your testimony, you mentioned existing laws already allow for expungement upon acquittal. What specific deficiency in the current petition-based process hinder fair and timely relief for acquittal for individuals?
I'm sorry, I couldn't hear you quite clearly there. Let me hear it again.
What specific deficiency in the current petition-based processes hinder fair and timely relief for acquitted individual?
Yeah, I mean, I don't have any problem with the existing law myself, the existing standards.
And at some point, I think in your testimony, you was not, and I don't know if, because I stepped out for a minute,
Sure.
you were not in favor of this particular bill. What's your position?
With this particular bill,
Yeah.
I do not favor it because the automatic expungement means that there's no discretion that can be applied by a judge, and no looking at the individual facts and circumstances or parsing anything. It just happens automatically.
And if by chance, do you know what's the shortest time someone gets their record expunged and the longest time?
I do not know. No, I don't know what the time frames are. I presume you're asking when someone files a petition, how long does it take for that petition to be ruled on? And I just don't know.
Yes, if someone was supposed to apply. I'll ask that question then to the public defendant office if you do have any knowledge of that.
Thank you, Senator. Our office does not handle expungements because it's not a criminal matter. Expungements are more of a civil matter, and that client would have to go to either the VI Justice Initiative, LLC, nonprofit agency, or they'd have to hire private counsel to seek an expungement. We believe that this automatic expungement assists clients because if we don't, by having the present law as it is where you have to petition the court, it penalizes a defendant whose own life has already been affected and their freedom already restricted. And who knows, they've been under the control of the court for a year, 2 years, 3 years. And so I believe automatic expungement allows them to get their life back on track faster.
All right, thank you for that. I'm trying to kind of figure out the process and the time involved in the process.
Time.
Because if I'll wrap up on this, Mr. Chair, may I?
Yes, you may.
And why I'm figuring this out, if there are current laws that are already doing it, if it's working in a timely manner, why do we do the automatic expungement? But if it's not, then I could see the need for that. And I understand both sides. I understand what the Attorney General is concerned about with a lot of DNA and files being secure for future reference. But thank you very much, Mr. Chair.
Point of information, Senator Lewis.
My question would be to Assistant Commissioner Santos. Is he still with us? Yes. Assistant Commissioner Santos.
Yes, sir.
Okay, good. Would your department, would the VIPD support a tiered expungement system where nonviolent offenses are automatically expunged and others go through a review process?
That is correct. We do support this bill, sir, Senator. And, however, we did have, we recommend that the bill have include specific safeguards, stipulations, especially in cases involving prior arrest of felonious violations.
Okay, Ms. Hodge, Chief Hodge, I saw you wave in. You have a response for me from before? Go ahead.
So in reference to your question about NCIC, once the court order is issued.
Come closer to the mic.
Once the court order is issued for expungement,
Yeah.
it is provided to NCIC. That information is passed on to the FBI, and all records are removed.
Okay. Thank you. That clears up a bit of stuff. And do you think that would hamper future investigations?
I think so.
Okay. Thank you.
Thank you. Senator Kenneth Gittins, you're recognized for your 5 minutes.
Thank you, Mr. Chair. Good afternoon to all. I apologize. I also stepped away earlier. And imagine while we sit here debating public safety legislation, senseless killing just took place in our Christiansted downtown area. That's full of patrons, business owners, etc., that has been for a long, long time crying out for help and looking for police presence. You know, as a retired law enforcement executive, again, you know, I can't stay silent. And while I understand the shortage in manpower of the Virgin Islands Police Department, I'm making a public plea once again that you must immediately develop and implement a redeployment strategy. I've been asking for this. This is the third commissioner now, I think it is, that I've been asking for this. We have to look at that redeployment strategy. Officers are going to have to come out of their comfort zones and hit the streets. Until we can get a number of individuals graduated and on the streets. You know, it's been some time that I've left the department, but I still hold it close and dear to me. And I really felt, I really felt those people in downtown when we just went down there, and they just came straight at us. So I'm asking again, please, please, please. I'm demanding that visibility, protection, and action now, not tomorrow. As it pertains to these bills before us, especially the automatic expungement, I didn't get to hear the pushback from the Attorney General's office, but this is a matter that I have been concerned about for quite some time as well, because it's not only costly but timely for individuals who are acquitted of a matter that can't get back their life per se. And I noted here on page 3 of the OTPD's testimony that most arrests here in the Virgin Islands are warrantless. And what I wanted to ask her, from your office clientele listing, what percentage would you say are affected by this, you describe it as civil death of discrimination? What percentage of your clientele you would say are affected by this?
95%, I would say.
95. That's a high number. And
Because
I figured
not many of them get an expungement.
Say that again?
Not many of them get expungements because it's not in the criminal case that they can get an expungement. They get an expungement by going to an attorney, a private attorney, or an agency that can file a petition for expungement. And there's only recently that we've had an automatic expungement for where no probable cause was found, and that was last year in the, I believe, in the 35th legislature. It was Senator, it was proposed by Senator Javon James and was passed by the 35th legislature. And that's an automatic expungement.
The automatic expungement, right?
Correct.
Right.
But that's only
So-
if there are no probable causes found.
And that's at the part, that's for the basic arrest at the advisement.
Correct.
Right. So this one takes it a step further, whereas you are actually acquitted after trial.
Correct.
And you
Time.
have at least 95% of your people affected by this.
Yes.
AG, what would you say from your perspective as well, from your office as the prosecutor? How much of this percentage-wise have you seen?
I do not know what the percent is. I don't see a lot of those petitions, though, passing through. My concern is...
So one second, before you go to your concern, don't you see these petitions? These petitions wouldn't come to your office as well?
They would go through our criminal division.
Right, so that's what I'm asking. And I'm glad that you're here. But this is exactly why when we're discussing these matters too, I always ask for the agency heads to send those people who are directly responsible for these pieces of legislation to come here and have these discussions. So I would have hoped to see your chief of criminal here so that we can get these answers. So the fact that the petitions go to their office, I mean, would you be able to get from them the percentage or the number that you have seen, the number of petitions coming to your office?
Yes, I will inquire of them today and get you those numbers.
All right, and again, I ask for future. When we reviewing these bills, we don't need, really and truly, we don't need the agency head themselves to come. I know you all are very busy, but make sure that your operators, those who are directly responsible that can answer the specifics, are here before us. The portion with the next bill now with the declaring a person incapable of consent to sexual relations while the person is in police custody. This thing had me baffled for a while. Assistant Commissioner or Chiefs, I mean, we had cases where people were accused of sexually harassing persons in custody.
Assistant Commissioner Santos, no, Senator.
Chief Hodge?
I only know of one case in which it was deemed false. Other than that, no.
Right, so you have accusations. And, you know, I asked that because I'm pretty sure that before I came back in, y'all had an opportunity to say, too, that your rules and procedures, your policy, your rules and regulations, your policies and procedures would cover things like this, correct?
That is correct, Senator.
And as a former supervisor of the Internal Affairs Bureau, one thing I always held on to, and I like to go to the books, I still have my blue book. And this blue book is the police manual. And I always tell people, I might sound prejudiced, that the Virgin Islands Police Department is one department I know have the strictest rules and regulations, policies and procedures. This book tell you even when you want to go to the bathroom to crap, how to do it, when to do it, and what you have to do. That's how serious this is. So it also addresses any complaint as this that comes before the police department. You also have the police department field manual that tell you how to handle matters out in the field. So, I mean, I totally agree to, I believe I heard your testimony that you stated, if anything, to make this measure stronger, because I always say you have all kind of police now. It's just like on the federal realm, so it's not a negative, but on the federal side, you got martial police.
you got park police, you got FBI police, you got IRS police, all kind of police. So in the Virgin Islands now, too, I don't tell them we got more specialized units than even the NYPD. We got DPNR police, we got DLCA police, we got taxi cab police, we got hospital police, all kind of police. Now they want school police too. And I am saying that while we're doing these things, then we have, just like earlier in the bill that we were discussing, now this bill should outline law enforcement officers and not just namely police in police custody. Police custody is a general terminology because, again, we have a whole lot of law enforcement entities that will come under this. So I believe we need to just do some work on this. I don't totally think we should ignore it because although we don't have a problem with it, we're forward thinking so that we can prevent these things from happening, so that things can be on the books, so that we can address it if it were to ever come up. So I'm hoping to work a little more closely with the sponsor of this measure. Thank you, Mr. Chair. At the appropriate time, hopefully we'll huddle before we vote on these measures and we'll move forward. But thank you for the time.
Thank you. Point of information, Senator Lewis.
Thank you, Mr. Chairman. Good afternoon again to everyone. Chief Hodge, help me to understand something. Let's break this down in layman terms. If an arrest is made today, let's say for a gun case, you caught me with a weapon. I'm going to use me as an example. You caught me with an illegal firearm. I got acquitted, and the case is expunged sometime after. After my expungement, I commit another crime. Would the VIPD know about the first case once it's expunged?
While you may have knowledge of it, as far as it being on a record, it wouldn't be there.
Okay. So there's nothing in no database would say Avery Lewis was arrested then, but his record has been expunged.
Well, yes, that would be on record.
Okay, that's the part I'm getting with.
Yes.
So you still would have knowledge, but you can't use the knowledge.
Right.
In a sense.
Well, I think what happens is when you appear to the VIPD to get a police record check, it would not be on the record.
Okay. But in the investigation world, you still would know some type of information of the previous arrest.
Yes.
Thank you.
Thank you. Point of information, Senator Fonseca, you're recognized.
Yes, thank you. Thank you, Mr. Chair. Yes, in regarding to the statement from the Vice President, we do have an amendment that we're prepared to move that defines detained, specifies the law enforcement official, and also clarifies the sexual relation. So we're ready to move that amendment. Thank you, Mr. Chair, for the time.
Thank you. Point of information, Senator Francis Heiliger, you're recognized.
I'm trying to save us a lot of questions because when I create legislation, I actually go and read what the code says before I amend it. And a lot of the questions that are being asked are already covered in the code. A lot of the concerns are actually written there. This section of the code says, a record of an arrest, a criminal complaint, or an information that does not result in a conviction must be expunged upon petition to the court if any one of the following applies. 1, where the case has been dismissed without prejudice and the statute of limitations has expired. 2, where the case has been tried and there was an acquittal. 3, where there is a statement of noel prosque, and the people have not filed for an information or complaint, and the statute of limitations have expired. Now, there is an exception where a judge could have discretion in Part B. Part B says the record of an arrest and complaint and information that does not result in a conviction may be expunged by petition to the court except in either of the following situations. 1, where the person flees the jurisdiction to avoid prosecution, or 2, where the person has a subsequent arrest, unless there are extraordinary circumstances for which the court finds the expungement is in the best interest of the public policy. This is already written in the VI code. All I am attempting to do, instead of the must part to expunge, just do it automatically so those people don't have to find lawyers, they don't have to waste time and spend years upon years to get their record expunged. That is all my bill is attempting to do. Thank you.
Thank you. Senator Noble Francis Jr., you're recognized for your 5 minutes.
Thank you very much, Mr. Chair, and good afternoon to everyone. Thank you for your testimony. I too want to weigh in on that broad daylight homicide that we saw today. We had the opportunity to walk through the Christiansted town area, and I'll tell you, we were accosted by several of the business owners and just kind of really demanding that there be some type of a presence within our town area. The Christiansted town, Project Set Town, is the epicenter of our business community and our economic engine, so it's critical that we're able to be responsive to the need of those business owners as we continue to be endeavored into finding reasonable revenues into this government coffers to run the government, to pay salaries, to pay overtime, to pay for services. Is essential that we continue to keep the revenues coming in. I think that this is the third or so homicide within that epicenter of the Christiansted town area in that particular boardwalk area, so over the last year or so. So again, I'm not telling the powers to be what to do, but I think that having these incidents over and over in the same location seems a little bit embarrassing. For us, it's a stone throw away from Government House. Again, it's our business area, and it's really creating a star for the business owners in the area. So we have to listen to them and be responsive. As it pertains to the measure before us, I just have a few questions, I understand, and commend the bill sponsors for moving some of these legislation forward. Obviously, there is always room for discussion, and I'd like to do that this afternoon. In Bill 36-0031, can anyone speak to what is the current expungement process and any time by which this is done, either the Department of Justice or the Virgin Islands Police Department? If you could just quickly just go over the process and the time limits. 0057, I'm sorry. Mr. AG, when expungement come before you, can you just quickly go over what that process looked like and what's the time frame within that?
Yeah, I have to say
process?
that during my year as AG, I myself have not had to review any expungements, so I can't give you any details on that process.
Okay, and what about you, Assistant Commissioner Santos? Are you familiar with the process for expungement?
Well, I do know, Assistant Commissioner Santos, I do know, Senator, that a portion of that process comes to the Virgin Islands Police Department, where the Chief of Police will review a document that's been sent to us from the court system, in which we review that document as to the individual, the crimes that are there to be expunged, and then our Chief of Police would sign off on that, allowing our our records division to begin a process, not only to look over the files, but also to begin a process in expungement. Once that is signed and certified, it's sent back to the courts.
Any idea of how long that process takes?
By the time we receive that document, Senator, it's looked over, signed within maybe an hour or so.
It'll be reasonable time once you receive it.
Yes, Senator.
Moving on, Chief Hatch, good afternoon. How are you doing today?
Good afternoon, I'm well.
All right, good to see you. In respect to Bill 36-0024, I heard your testimony and you're very much in support of this. Do we have any general order of the police department that covers how we process individuals within police custody?
Can you repeat the question?
Do we have any general order, a policy within the Virgin Islands Police Department, how we handle individuals in the police custody?
Yes, sir.
And anything that seems to be nefarious or improper, especially as it pertains to sexual contact, could also lead to not just arrest, but also termination as well, correct?
That is correct.
Okay, very well. And your support for this is for it to be codified in addition to what you're seeing within the rules and procedures.
Yes, sir.
Thank you. AG Ray, I know that you spoke about the issue of acquittal. In this case, I heard on a question that you spoke about acquittal, but isn't acquittal, again, where the prosecution had failed to meet the defendant, or meet the standard, and that the defendant, beyond a reasonable doubt, and the court, either a jury or a judge, has determined that the matter is acquitted?
Yes, that would be an acquittal.
So what do you believe needs to be additional information in regards to having the record removed if in fact the judge, jury have then deemed that that person or that defendant should be acquitted? What do you believe is additionally necessary for that record to be removed from that person's file?
Well, obviously there has to be a petition to the court to have the record removed. And the thing that is of concern to me is that not only is the public record removed, but under these various rules, it will also be the removal of DNA evidence, fingerprints, anything at all like that. And if the person, let's say, has committed crimes of this sort in the past or does it again in the future, I hate to see material that can be relevant to investigating and identifying offenders destroyed or removed.
So I think you're going a step further because you're pushing those detailed issues. We have created legislation to allow for a DNA bank. This don't speak to. They talk about removing the record of the acquittal from the rap sheet of that individual. Any other information that's contained for investigatory purposes, should remain. However, when you do a record check on that person, clearly it should show the acquittal. So I think, again, creating those type of delay specification could be more detrimental to investigation rather than just adhering to what this is calling for, which is for the removal of the record from the files. Would you agree with that?
If it were just the removal of the record from the files of the acquittal, well, of the charge, that would be one thing. But this calls for, and I'm looking again for my copy, don't see it right off the bat. This calls for removing virtually everything, including prints, DNA, all of that sort of stuff, which could be valuable in the future.
So you're saying that you require a court order, or you're insisting that it would be better for the court order to indicate exactly what should be removed?
I think that would be ideal, yes. Although, yeah, I think that would be, because that would let the judge make that kind of a judgment. And again, it'll vary with individual cases.
Madam Territorial Public Defender, what do you say about that?
I think we're penalizing the poor. We are a community of mainly brown and black, and we're penalizing our brown and black men and women who live in this community by not allowing their full records to be expunged upon an acquittal. An acquittal meaning that they were found not guilty.
And not guilty, remember, does not mean a jury found them innocent. What the jury found was the government had failed to prove beyond a reasonable doubt their guilt.
And why continue penalizing them when they were found not guilty?
And if what's preserved is simply things such as DNA, fingerprints, and that sort of thing, there would be no penalty on them unless those became relevant for a future event. So,
prosecution and defense, my son.
we're still good friends. Yes.
Of course. No, those are. I guess that's the kind of argument that you're seeking, AG, where you want to have that discussion and an open court to determine what should be removed and what should not be removed. So we hear it here, and we'll hear it at the court as well. Thank you for responding. I think I heard my time call, and I appreciate the leniency, Mr. Chair. Thank you. I'm not a member of this committee. I don't have a vote either way at this time, but certainly when it comes before me in the full Senate, I'll support.
Point of information.
Thank you.
Point of information.
Thank you, Senator Francis. And point of information first goes to Senator Alma Francis Heiliger.
Thank you.
Then you get it.
Thank you so much for the time. I just want to put this quickly on the record because I don't want wrong information being put out there. Because what was being stated earlier is all of these things are in this piece of legislation. This is a very short 2-sentence legislation that says, upon the acquittal of an accused, the court shall enter an order to expunge the accused's record of arrest and the criminal complaint or information upon which the accused was tried. That's it. Period. All of the other stuff that was just said is not in this bill because our law already gives the law the right to erase all of these things right now. Because if you go and petition a judge right now, our law says you must get expunged if you're acquitted. All of these things must disappear. I am not changing any of that. I am adding a section C. A is already there. B is still there. I am just adding a C. Thank you.
Thank you. You recognize Senator Giddens for your pointer.
Thank you. I wish I was there in the St. Thomas chamber so I could just have my colleague to just take it easy. All will be well. And I understand her frustration, and I understand the legislation that's coming before us because, again, this matter of expungement is not only timely, but it's costly. And what she's trying to do here is allow all the time and cost to go out the door. But at the same time, we also want to be responsible in this, and that's why it's crucial that you all put the process of the expungement on the record, because folks who are watching and listening are now believing, and we're seeing quite often now where witnesses are being threatened and there's no follow-up by law enforcement to address those threats, and as a result, witnesses are not coming forward. Witnesses end up being found dead. And then if you have an acquittal, then what? There must be a process in place. And so I believe that if we were able to explain the process, that people would understand it's not just so automatic, but it will still have to take these steps before the expungement is done. It just would not be as timely and as costly. So I think I did heard one of my colleagues ask already of the AG, what's the process? And I'm hopeful that before we leave or before the actual final passage of this bill, that process is able to be explained thoroughly, especially so that people could understand you can't just be threatening people, witnesses in particular, and next thing you know, because a witness is threatened, I ain't saying nothing again, and then you're acquitted. Or the AG's office says, I have nothing to go on because all I had was a witness statement and the witness is now dead, so I don't have any physical evidence. And that just happened in the Shang incident. So please, thank you.
Thank you, Senator Gittins. I'm now recognizing Senator Dwayne DeGraff for your 5 minutes.
Thank you, Mr. Chair. Thank you, colleagues. Good afternoon, testifiers. Assistant Commissioner Santos.
Yes, Senator.
Chief Deborah Hodge put on the record acting. Let's done it, no man. She win all the Academy Awards, all of them things for acting. Come on, man, you know. Putting out another plea, 29-year veteran, first female. Let's do what we have to do, man. Just stop acting, okay? Thank you.
Short order, sorry. Short order. We'll be taken care of.
For Vitima, for 360031, you have a phrase in here I don't like or don't understand. In terms of a public safety agency or private safety entity, its employees, agents, contractors, and affiliates shall not be held liable for acts of negligence in operation. If you're admitting negligence, how are you not held liable? What does that mean?
Honorable Senator, I'll hand this over to Deputy Director Bruce Kelly.
Good afternoon, Senator.
Good afternoon.
If you, could you repeat your question?
In the bill, you have a copy of the bill?
Yes, sir.
Section 1C, a public safety agency or private safety entity, its employees, agents, contractor, affiliates shall not be held liable for acts of negligence in the operation. So we're saying there are acts of negligence that they shouldn't be held accountable for. What would be an act of negligence that you shouldn't be held liable for? Put it that way. Or an example.
I would go out and probably put an example as a equipment failure. I don't know if I'd call that negligence, but it would have to be something like that.
It's not. Is giving the wrong directions or something like that considered a negligent act, but not gross?
Yes, Senator.
So something like that?
Yes, if a squad leader gave the wrong directions and didn't get the full situation and gave the wrong directions, then yeah, that would be an act of negligence.
They say a bomb is going to go off at 10. If they don't say AM or PM, negligence. So different like that. Okay.
Right.
Okay. So I got it. No, except gross negligence, which again we understand gross. Okay. So I got that one. 360024. I was a police for 26 years, and you ain't got to tell me if you do something like that, pay the price. So wherever the price is going to be, and your bill don't have any penalties, we'll go based on what the law is or what the policies of the department are. Pay the price. You arrest somebody, you're supposed to take care of that person with dignity and pride. And if I could do it for 26 years, I ain't accepting nobody who's going to do it any different. So I'll support you on that. 360057, I'll support this too, because Chief Hodge, how much you to pay when you get arrested and they fingerprint you and stuff and things? When you're under arrest, how much you got to pay?
For a police record?
No, I mean when I am the person arrested and they take my fingerprint, they take my DNA, how much I got to pay for that? Not a dime, right?
No,
not a dime. Zero.
That's a question.
Zero. Not a dime. No. And imagine the word in the bill or the phrase has been acquitted. In the English language, acquitted means you won the case. You have won the case. You have presented your case. The government have presented their case. Your case won. If a judge decides an expungement, wherever it's along the lines is going to be gone. But in specific, as my colleague read, this bill, upon the acquittal of an accused, the court shall enter an order expunging the accused's record of arrest and the criminal complaint or information upon which the accused was tried. But Attorney Todman, what would you say is the amount an individual has to pay to have their record expunged?
Well, a good friend of mine, Attorney Casey Payton from the VI Justice Initiative, I initially said LLC. It's not an LLC, it's a non-profit, a legal non-profit. Their office does these expungements. And she testified when the bill came up for the automatic expungement at probable cause and no probable cause is found. She testified that it costs, or the value of their services is about $2,500 per client. And so those are the persons going through the VI Justice Initiative, but they can only assist so many persons if they don't have the funding to assist everyone. So then sometimes someone will have to go find a private attorney, and there are many persons who cannot afford to hire someone, our indigent persons, our brown and black, and we are, I don't know if we're 80% brown and black. The majority of our clients are brown and black, cannot afford to hire an attorney to file for an expungement. So many of them do not get an expungement. So it affects them when it comes for housing, when it comes for jobs, when it comes for many other programs. So, and she, like I said, she testified that it costs about $2,500 for their services.
Thank you. And in closing, Mr. Chair, it's like I say, I have done my job for 26 years, arrested individuals, but when somebody has gone through the process and been acquitted, which is in the bill, they've been acquitted, they didn't just, we lost the paperwork, so we're releasing you. You went through the process, you're acquitted. Then years upon years, they can't get a job to even pay for the expungement because they have a rap sheet, different things like that. But again, I think it's only fair that automatic expungement go through once the person has been acquitted. The judge has his process of going through it, but we are trying to help out the entire system now by going through the process of after they've been acquitted. Thank you for the time, Mr. Chair.
Thank you, Senator DeGraff. The mic will now be recognized. Senator Fonseca's mic for 5 minutes.
Thank you.
Point of information.
Thank
point
you,
of information.
Mr. Chair.
Point of information. One second.
You're recognized for your point of information.
Thank you. Sorry about that. Can you just tell the online testifiers that if they're asked a question, to please put their name and title on the record. They've been responding, but some folks don't know who they are. Thank you.
Thank you. You're recognized, Senator Fonseca.
Thank you, Mr. Chair. For Carnival, I met this one guy. He had a, criminal record. He did something. He was 40 years. He was orphaned at 3 years old, so he didn't know his mother and father. He did something, he paid his time, and he was 40 years old, and he was saying, I have a lot of skills, I've been to college and stuff, but I can't get a job, So, he struck me to be, this is the first time I met him, but he struck me to be very nice. He knew that I was a senator, and he wanted me to help him out to get a job, but I know that that criminal record was going to be tough. He actually said he wanted to be a police officer. So let me ask the question to Ms. Combs or Attorney Ray. If your record is expunged, would you qualify now to be a police officer?
Is that question directed to me?
Yes.
Okay. Acting Chief of Police Hodge.
Hodge, I'm sorry, Hodge.
Yes. So anyone that applies to become a police officer has to get a background check. It doesn't just depend on your expungement record. So there's a possibility, yes, but there's other processes that are associated with becoming a police officer.
Okay, good. I wanted to clarify, right, that sexual assault is already prohibited. And Bill number 360024 provides clarity, and it's specifically stating that individuals in police custody cannot legally consent to sexual activity with an officer. You see, there's a power imbalance in such situations inherently that prevents genuine consent. And this bill would close that legal loophole and strengthen the protections for vulnerable individuals. The bill does not unfairly target officers. It holds them to a standard, a federal standard, that's consistent with other roles, persons in authority, such as teachers or healthcare providers. And the bill does not change the burden of proof of due process protections for officers. Investigations and prosecutions will still require evidence. What the bill does is clarify that any sexual contact in a custodial setting is by definition non-consensual under the law. So I wanted to ask you, Officer Hodge, because we know that sexual assault is prohibited, but right now, and we're going to use the term in the amendment, can any law enforcement official use sexual consent as a defense in a case? Attorney General Ray or Officer Hodge, can they use sexual consent? In others, can they say that the person was consenting?
So your question is quite general. So you can always use it being consensual as a defense, but I think what we're referencing here is being in custody.
Right. So in custody, it will not be used. It cannot be used.
Right. It cannot be used. Even we have administrative penalties for engaging in sexual encounters with persons that are in custody. So that cannot be utilized.
The question is, right now, can any law enforcement official use sexual consent? In others, can they say that the person gave them sexual consent as a defense?
Not if you're in custody. I think that is the question.
That's
because
the question.
Right.
Gordon Ray, is that codified right now?
Not that I'm aware of.
Okay.
My thought would be
Right.
that at this stage, in the absence of the proposed legislation, if you're sued and you're a police officer and you had sex with someone, obviously the victim would say, I was forced, and the policeman would probably be saying, no, they totally consented. And
They
it would be up to a
consented,
jury.
right.
And it would be up to a jury to decide
Hold on.
whether or not.
Come closer to the mic.
It would be up to it would be up to a jury to decide whether or not there really was consent. Because the whole issue of the power of the official would obviously come into play.
And what this bill does is that would no longer be a defense for the law enforcement official. They will not be able to say they had sexual consent. That would not be a defense.
Correct.
So that's the loophole that this bill clarifies. So even though my esteemed Vice President pointed to his big blue book, right now law enforcement officials, and I'm sure it's not VIPD, but since we're talking about law enforcement officials, they can use sexual consent. This bill removes that loophole. I wanted to go, time was called?
Time was called.
Oh, okay.
So you got to wrap up.
Can I wrap up? Yes. So I wanted to go real quickly to Ms. Todman, because the recidivism issue comes up, right? In that the persons that were previously convicted of a crime, you had mentioned that they once it's expunged and they've done this, they are less likely to commit a crime. And you referenced that case, and I Googled it, and you actually was right. So I support the bill, 57 and 31. I support both of them because I think they're good for our system, especially the 911 operators, because they're really sworn to help the community. Thank you, Mr. Chair, for the additional time.
Thank you, Senator Fonseca. I now recognize the mic of Senator Alma Francis Heidegger.
Thank you.
For your 5 minutes.
Good afternoon to my colleagues, the people of the territory, to the testifiers and staff. I do support 360020. Anything that we could potentially, whether it's done by policy or we could even get it codified in the code to clean up or eliminate potential loopholes according to the sponsor. This is a no-brainer for me because this should not even be happening if somebody is in custody. Can you really give consent if somebody's already saying, I am taking you in outside of your will? So if you are in my custody, if I had the freedom to do what I wanted, I wouldn't be there. So it's kind of a simple legislation for me. As it relates to 360031, our current law already prescribes that if someone is already acquitted, they could go ahead and petition our court system, and they must be granted an expungement. And this expungement would basically include everything. I am not changing any of that in the code. I am simply saying that because we do live in a society where our judicial system takes a very long time to do quite a bit of things, why force people to have to go through a trial, get acquitted, and still have to figure out, after their lives have been disrupted, try to figure out how to potentially come up with $2,500 to get their name cleared? That is not fair to them. And I'm also looking at it from looking at some of the concerns that were brought up here today. Well, maybe we should allow a judge to decide what should be kept, what shouldn't be kept. Based on our current law, there are specific reasons that a judge can go in and make those decisions if somebody tries to flee, if somebody's rearrested. So there are grounds for some of the concerns that were discussed that is already written in the code. My concern is putting out a situation where someone has already been judged by 12 of their peers or a judge, and then for them to get expunged, they now have to go ask a judge to decide, hey, should you let me go and clear my record or not? Our law already says they have to do it, so why make them pay? My thing is clean it up as quickly as possible. We cannot, and I love the stats that the representative from the Public Defender's Office did share with us, that when people's records are expunged, recidivism is reduced. Because can you imagine, I was arrested, I was not convicted, I'm considered acquitted, and I get a traffic stop. The officer goes and checks and my record shows up. All of a sudden now, even though I'm in the clear, you have now planted a thought and an idea into that officer's head. Oh, they must have done something. Something must be going on. And maybe all of those are the things that tie to why people might even get rearrested just because this record exists. So my thing is, if we've already followed the rule of law and these individuals are acquitted, don't make them suffer anymore. Allow them to clear up their lives as much as possible so they could continue on and continue to be citizens in our society, hopefully law-abiding. If they get rearrested, I don't have anything to say because our court says we'll deal with you then. There was also some concerns about clearing out DNA and getting rid of all this information. Even though somebody is acquitted, even though if they get the opportunity to get their record expunged, we live in a digital age. Everything doesn't disappear. If you go, every online newspaper will still have an article maybe of that case. Every social media location, people might have discussed that case. So in the age that we live in the 21st century, even though records are expunged, that you might, could I quickly wrap up?
Yes, you could wrap up.
Thank you. You might not be able to go in and grab that record, but it doesn't fully disappear. So there's always going to be some stamp on our society where you could still find information about it to say, well, hey, this person might not be as squeaky clean as you think. So I can't really subscribe to that argument. And the last bill, 360031, with all the discussions we've had, we've clearly, hopefully explained between ordinary negligence and gross negligence. Simple things could happen with a 911 operator. For example, instead of putting in 903, sometimes with me typing, I might type 90E because just how it's on the keyboard. That's ordinary negligence because sometimes mistakes happen and that might have caused a delay. But when you deliberately do something like, for example, if you made a mistake and you went in and tried to change records, those things are considered gross negligence. So that's all I'm trying to say. Please allow our people to serve and be the public servants that they are, and just exempt them for things that we know that could be human error, but things that we know that they're doing deliberately that could potentially cause harm or hurt individuals, we hold them accountable for that. That is all the legislation is attempting to do. So I want to thank all the testifiers. The only question I have to Ms. Todman, the question I want to ask you is, in drafting this legislation, I only had one other question in regards to dismissals with prejudice. Would you consider that falling under the same similar category as acquittals? Or do you think that should go through the process to request a judge to expund it versus just having that automatic as well? Thank you.
I believe that a dismissal with prejudice is already under, I believe, our statute as it presently exists, and they have to file a petition. Personally, I do believe that when there's a dismissal with prejudice, a judge has made a determination that either the facts are not there to support the charge going forward, and so the prosecutor does not have the evidence to proceed with the matter. In that case, I believe that there should be automatic expungement also. Again, I do believe that what we have is that we have poor people who cannot afford the cost of an attorney, who need to have their records expunged so that they can go on and continue with their lives and have good, productive lives. And we're passing laws, and we have laws in place that affect their ability to do that, because most of them will not seek an expungement because the first thing, they need another attorney to do that. They don't have the resources to do that. So we have an imbalance between those who can afford and those who cannot afford private counsel.
Okay. Thank you, Mr. Chair, but just for the record, a dismissal with prejudice means that the case is basically closed out and they are not going to bring it again.
Yes,
okay? Thank you.
Yes. Thank you, Senator. Oh. Wait. You got it. Senator Gittins, you're recognized for your point of information.
Thank you, Mr. Chair, for the record and for the benefit of especially my colleague. I support, I'm leaning on supporting his measure, but I want him to understand how serious these table of charges and specifications are. There's about 5 different articles within the police department. The first one covers conduct on becoming an officer, and it has about 17 sections, to include even gambling while on duty or illegal gambling, and even if you owe a debt. All right? So, and then Article 2, you have even being under the influence of an intoxicant. Article 3 deals with neglect of duty, to include failure to comply with the commissioner's general orders, special orders, directives, etc., and even engaging in idle behavior. Article 4 speaks of disobedience of orders, and it has about another 22 sections under there. And then the last one speaks to conduct prejudicial to the good order of the department. And that's your catch-all, because if it's not specifically written there, it's telling you performing any act or omission not specifically covered in the rules and procedures, charges and specifications which may be prejudicial to the good order of the department. And I understand and acknowledge that this should be across the board for all law enforcement officers, but I thought that I would put that on record just so that my colleague could understand how serious this book is. Thank you.
Senator DeGraff, you're recognized for your motion.
Thank you, Mr. Chair. I move Bill number 36-0057, an act amending Title 5, Virgin Islands Code, Chapter 314, Section 3733, subsection A, to require automatic expungement of the arrest record and complaint or information when accused has been acquitted, be voted on favorably in this committee and forwarded to the Committee of Rules and Judiciary for further consideration. I so move.
Second. A motion has been made by Senator DeGraff, second by Senator Lewis and Senator Fonseca.
Roll call.
Hearing no objection. Roll call. Roll call on bill number 36-0057.
Senator Angel Bolquez Jr. Senator Bolquez, yes.
Wait, say yes?
Senator Dwayne M. DeGraff.
Yes.
Senator DeGraff, yes. Senator Ray Fonseca.
Yay.
Senator Fonseca, yes. Senator Kenneth L. Gittins.
Yes, with an explanation. Yes.
Senator Gittins, yes. Senator Franklin D. Johnson.
Yeah.
Senator Johnson, yes. Senator Avery L. Lewis.
Yes.
Senator Lewis, yes. Senator Clifford A. Joseph.
Yes.
Senator Joseph, yes. Mr. Chair, you have 7 yes.
Bill number 36-0057 has been approved by the Committee on Homeland Security, Justice and Public Safety, and will be forwarded to the Committee on Rules and Judiciary for further consideration and action.
Motion.
Motion, Senator DeGraff.
Thank you, Mr. Chair. I move Bill number 36-0031, an act amending Title 23, Virgin Islands Code, Chapter 10, Subchapter 4, Section 1073, to exempt a public safety agency or private safety entity from liability for acts of negligence in the operation, administration, or maintenance of a 911 service unless the acts are committed in a grossly negligent manner or are committed with willful intent. Be voted on favorably in this committee and forwarded to the Committee of Rules and Judiciary for further consideration. I so move.
A motion has been made by Senator DeGraff, second by Senator Lewis. Roll call. Number 36-0031. My bad.
Senator Angel Bolquez Jr. What do you say? Say yes, no?
He said yes.
Okay. Senator Bolquez, yes. Senator Dwayne M. DeGraff.
Yes.
Senator DeGraff, yes. Senator Ray Fonseca.
Yay.
Senator Fonseca, yes. Senator Kenneth L. Gittins.
Yes.
Senator Gittins, yes. Senator Franklin D. Johnson.
Yes.
Senator Johnson, yes. Senator Avery L. Lewis.
Yes.
Senator Lewis, yes. Senator Clifford A. Joseph.
Yes.
Senator Joseph, yes. Mr. Chair, you have 7 yes.
Bill number 36-0031 has been approved by the Committee on Homeland Security, Justice, and Public Safety and will be forwarded to the Committee on Rules and Judiciary for further consideration and action.
Motion.
Motion. Senator Fonseca.
Thank you, Mr. Chair. I move Bill number 36-0024, an act amending Title 14, Virgin Islands Code, Chapter 85, by adding Section 1710, declaring a person incapable of consent to sexual relations while the person is in police custody, be voted upon favorably in this committee and forwarded to the Committee on Rules and Judiciary for further review and action. I so move.
A motion has been made by Senator Fonseca, second by Senator DeGraff. Roll call. Roll call.
Objection.
An objection by Senator Gittins. Roll call on the bill. Bill number 36-0024.
Senator Angel Bolquez Jr.
Recognize.
Me.
He said yeah, no, me here, but. Oh.
He said yeah.
Senator Bolquez? No.
What do you say? What's your vote, Senator Bolquez?
Nay.
Nay, okay. Good.
Senator Bolquez, no. Senator Dwayne M. DeGraff? Yes. Senator DeGraff, yes. Senator Ray Fonseca? Yes. Senator Fonseca, yes. Senator Kenneth L. Gittins?
No.
Senator Gittins, no. Senator Franklin D. Johnson?
No.
Senator Johnson, no. Senator Avery L. Lewis?
Yes.
Senator Lewis, yes. Senator Clifford A. Joseph?
Yes.
Senator Joseph, yes. Mr. Chair, you have 4 yes and 3 noes.
Bill number 360024 has been approved by the Committee on Homeland Security, Justice, Public Safety, and will be forwarded to the Committee on Rules and Judiciary for further consideration and action.
Point of personal privilege.
You're recognized for your point of personal privilege. Senator Gittins.
Thank you, Mr. Chair. I don't usually do this, but I will put on record that my vote of no was because the champion of the bill stated that he will be amending the bill, and he didn't state on the record at what point he will be amending the bill. So whenever the bill is amended, then I will consider change in my vote. Thank you.
Thank you. Point of Senator Fonseca, you're recognized for your point of privilege.
Yes, thank you, Mr. Chair. We have ready amendment number 36-348, but we have decided to approve it and forward it to the Committee on Rules and Judiciary, and the amendment will be brought forth in the Committee on Rules and Judiciary at the appropriate time. Thank you, Mr. Chair.
Thank you. At this time, Senator Avery Lewis, you are recognized for your point of personal privilege.
Yes, thank you, Mr. Chairman. Mr. Chairman, you know, today we had a good run. I'd like to congratulate you on a well-run meeting today. I'd also like to just say, put it out there in the community that I know at times we would like for the law enforcement to be everywhere at all times. But I'd also like to remind the community that we do have a part to play, and just ask them when we see something to say something. I mean, you don't have to give your name. There's many different avenues and outlets that you could just give your name, give some information. We can't just wait till it always hit at home and it affects us. We must take part. Yes, VIPD have their work cut out for them. They know what they have to do to step up to the plate. But I'm just asking the community and then to the misreads out there actually to, you know, just pick up the Bible, pick up the attitude of showing more love, and let's reduce the violence. Again, condolences goes out to all who was impacted today. You know, when I hear these type of things, I don't care which island it is. I'm a Virgin Islander, it impacts me. So I just ask again, please, let's just show a little more love in this community, a little more love to one another. Thank you, Mr. Chairman. Again, well-run committee meeting. Thank you.
Thank you, Senator Lewis. And I'll give a point of privilege to Senator Alma Francis Heiliger.
Thank you. I just want to take this opportunity to thank the members of this committee for supporting the two pieces of my legislation. These legislation were born out of protection as well as giving individuals another opportunity of having a clean slated life. I think it's very important that as the representatives of the people, we look at the things that are directly impacting those in our community and come up with laws to make sure that we make their lives better. So hopefully with the expungement piece of legislation, it will clear a pathway to assist those to move on and clean up their lives and get opportunities that they might be hindered from getting if their records were not instantaneously expunged once they have been committed of something they have been accused of. Thank you very much, Mr. Chair, for the time.
Thank you, and at this time, I'll give the testifiers 30 seconds. I'll start with the Assistant Commissioner, since you're over there in St. Croix, give you 30 seconds to wrap up, and we'll do.
Thank you, Honorable Senator Clifford Joseph Sr., honorable members of the 36th Legislature. On behalf of Police Commissioner Mario Brooks and the men and women of the Virgin Islands Police Department, we would like to extend our heartfelt gratitude and opportunity to testify before you today. Your willingness to listen and engage with us underscores your commitment to the safety and well-being of our community. I am deeply appreciative of the time and consideration you have given to our testimony. The insights and feedback provided during this session are invaluable as we continue to work collaboratively towards enhancing public safety and fostering trust within our community. Thank you once again for your support and dedication. We look forward to continue our partnership, and together we can achieve our shared goals. Thank you.
Thank you for your testimony of good support.
Good afternoon. I think that AC Santos spoke on my behalf, but I'd like to thank you for having me here. And just rest assured that VIPD is committed to serving the people of this territory.
And thank you for the service. Good.
Todman, on behalf of the Office of the Territorial Public Defender, I would like to thank the committee for having me present. I just want to say that I'm excited that Senator Alma Francis Heiliger proposed Bill 36-0057. I believe that it is a racial justice issue, and that by passing this bill, and automatically expunging the records of Virgin Islanders who have been acquitted, it's an economic and social mobility issue, and part of the Clean Slate Project for our people. Thank you.
Thank you.
Yes, Attorney General Gordon Ray, and on behalf of the Department of Justice, I want to thank you very much for giving us the opportunity to testify at this hearing, and we look forward to doing it as more legislation comes through. And I think I appreciate the way that you run the hearing. It was, I thought, fair and gave everybody a chance to have their say. And I think this kind of debate and discussion is important. So thank you very much.
Thank you. So thank you to all of the testifiers for coming out. You guys are released. At this time, I'd like to give my sense of congratulations to the latest 12 first responders for the fire department. Yesterday, they had the graduation on St. Croix. They had 12 EMT firefighters that completed their training. So I kudos to the men and women in the fire department and to the personnel that train these individuals and the management of the fire department. Again, thank a committee on Homeland Security, Justice, and Public Safety meeting on June 5th, 2025 is hereby adjourned.